or descendant. Pero kung asawa po ng anak, hindi po to covered ng privilege, ng filial privilege, Your Honor.
May I remind the gentleman that under the rules of this court, every member of the Senate has only 2 minutes to speak.
Yes,
And,
Your Honor.
we are tolerant, but I would like to read for the information of the gentleman that the grounds of impeachment are culpable violation of the Constitution, treason is a crime, bribery is a crime, graft and corruption is a crime, and other high crimes. And that is why this chair considers this proceeding akin to a criminal case.
Yes, Your Honor. I do not disagree with that, Your Honor. But I disagree with the ruling, and I do not want it to be a precedent, Your Honor. That's why I brought it up before some members in our discussions about whether or not a subpoena can be issued, and I'm asking that the Senate decide whether or not they should be issued a subpoena. And Your Honor, may I please point out, there is a difference as to the plea to the issuance of a subpoena to the CJ himself, the wife, the child, the children, and the son-in-law, Your Honor.
We note the opinion of the gentleman, and may I request him to please allow the proceedings to go on.
Yes, Your Honor. I'm not delaying the procedure. I'm simply making the motion to amend the ruling, wherein the ruling as far as the CJ will stand, but as the ruling to the children and to the son-in-law and the wife, that the subpoena be issued by the Senate, Your Honor.
Are you appealing the ruling of the chair to the body?
Yes, Your Honor.
Well, then I'll put it to a vote. The majority floor leader.
If the body is willing to take a vote, we are ready to take a vote, Mr. President. But there is a suggestion that a recess be called by one of the members.
Session suspended for 1 minute.
Ay, June.
A recess has been called by the presiding officer after the Senator Alan Peter Cayetano stood up to challenge the ruling of the presiding officer on the motion to subpoena the Chief Justice, the wife of the Chief Justice Corona, the children, and the son-in-law. Kaya po, ang base sa procedure, meron po silang dapat gawin. Kaya tanong natin sa ating mga legal consultants, siguro kay Attorney Caloy. Attorney Caloy, can you help us understand what just happened?
Well, the subpoena was filed by, the request for subpoena was filed by the prosecution side, and it was denied by the Senate President. Surprisingly, after that, the motion to have the Senate President reconsider his decision was withdrawn after the Senate President gave an explanation. And then to add to that, there was a Senator Judge Cayetano who surprised everybody by giving his personal opinion. So I was not sure if the prosecution was going to ask for reconsideration once again.
They asked for a reconsideration and then they submitted.
Yes.
Pagkatapos sinabi ni Senator Enrile na decide na nila and then based on these grounds.
What does the internal rules of impeachment say about this situation, Attorney Joey?
Ang sinasabi ng Article 6 of the impeachment rules ng Senado is that kapag nagkaroon ng desisyon ang presiding officer, ngunit merong isang miyembro ng Senado na gustong tumayo at questionin ang desisyon ng presiding officer, meron siyang karapatan na magpaliwanag at humingi na magkaroon ng boto tungkol dun sa desisyon ng presiding officer. Nung unang hinain ni Senator Cayetano ang kaniyang mga dahilan kung bakit hindi siya sumasang-ayon sa kabuuan ng desisyon ni Senator Enrile, nung una hindi pa niya hinihingi na magkaroon ng botohan. Ang sinasabi niya baka sakaling itong prosecution ay gustong humingi ng
mukhang nagsasuggest
motion for
lamang.
consideration. Oo. Pero dahil nga na-clarify ni Senator Pangilinan na itong prosecution ay nag-submit na, sumang-ayon na sa desisyon ng presiding officer, naging alanganin. Parang nawalan ng karapatan ng prosecution na humingi ng motion
Pero
for recall.
paano ba yung proseso? Yung presiding officer lamang ang nagdidesisyon kung i-grant niya yung motion o hindi. And then, kapag may mga question, tsaka lamang boboto yung buong Senate body. Ganun ba?
Parang gano'n ang lumalabas sa Article 6 ng ating impeachment rules, ano? Na pag merong miyembro ng Senado na gustong humingi ng boto, after na magkaroon ng desisyon ang presiding officer, ganun ang magiging proseso. Ngayon, medyo nagkaroon sila ng problema kasi si Senator Soto, sinubmit na niya for votation itong motion ni Senator Cayetano na magkaroon ng botohan tungkol lamang doon sa ruling laban sa pag-issue ng subpoena doon sa son-in-law ni Justice Corona.
Pakipaliwanag nga, Attorney Caloy, kung bakit inargue ni Senator Cayetano na iba dapat ang turing
Yes.
kay CJ Corona, iba yung turing sa asawa at sa mga anak at sa son-in-law. Briefly explain kung ano yung pagkakaiba.
Well, actually, his argument covers everybody. What he's saying is that why suppress it at the subpoena stage when those provisions in the rules of court are to be invoked by the witness or by the individual concerned. Do not suppress it. Do not preempt. Do not suppress so early. So I was expecting that he will ask that the vote be taken with respect to all of them, but he's sparing the Supreme Court Chief Justice apparently, and starting with the wife, the children, and the
So,
in-laws.
okay, paliwanag lang natin. Ang gusto ni Senator Cayetano, ma-issuehan ng subpoena, mapatawag at mapapunta, maging witness itong pamilya ni Corona, but that does not parang remove the fact that pwede silang mag-cite for self-incrimination kung ayaw nila sagutin ang isang bagay. Ganon.
Yes, it was obvious he felt very awkward being the one raising the question.
Yes.
But according to him, he cannot in conscience remain silent with due respect to the presiding officer Enrile. He could not in conscience allow them to suppress this evidence without informing his fellow senator judges.
Mukhang, help us understand, Attorney Joey, dahil kumpara sa regular proceedings or regular trial, pumayag na yung prosecution, nagsabi na silang we submit. And yet, yung senador, si Alan Peter Cayetano, kinwestiyon niya mismo yung ruling ng presiding officer. How is this still proper?
Well, it is proper because the rules on impeachment allow it. Itong pinagkasunduan ng mga senador na mag-govern sa kanilang procedures. So, pwede ito. Yun lamang nagkaroon ng, gaya ng sinabi natin, awkward moment dahil nag-submit na ang prosecution na tinatanggap nila ang desisyon ng presiding
Paano yun?
officer.
So, on record na yun, pwede bang baliktarin ng Senado kahit na nag-submit na? Ganun ba?
Pwede pa yon kung ang boto ng Senado ay magkakaroon sila ng panig para doon sa pag-amend ng ruling. Doon lamang naman sa in-law ang sinasubmit for voting ni Senator Cayetano. Sinasabi niya, siguro para doon sa son-in-law, pwede tayo mag-submit, mag-issue ng subpoena dahil hindi naman siya covered nung tinatawag na filial privilege. Ibig sabihin na ang anak ay hindi pwedeng magtestigo laban sa ama.
So, itong defense, hindi natin nakita na nag-object, no? Nothing came from them with that. Could they have objected?
The defense?
Yeah?
Well, they kept quiet, so I suppose...
Kasi nga, as it stands,
Fine.
pabor sa kanila.
Yes.
As it stands, the ruling. Siguro, moving ahead, anong pwedeng mangyari dito, Attorney Caloy? Dahil, this was a ruling made after assessing motions or written documents submitted, meaning nag-submit ng written motion yung depensa, nagpadala ng subpoena muna motion yung prosecution, nag-oppose naman itong depensa. At gusto nga ipaliwanag ni Attorney Cueva, sinabihan na siya ni Juan, huwag ka nang paliwanag, meaning pinapayagan na yung inyong objection. So, moving forward, para maiwasan ito, ano yung sa tingin mong mas magandang mangyari sana?
Although awkward at first, wala naman problema actually. Everybody was able to correct themselves, get their bearings. So, I think it's Section 6 of the Senate Rules they're invoking. So, once and for all, the senator judges will decide the matter.
Kapag nung nagbigay ng manifestation itong si Senator Cayetano, shouldn't there, before a vote, hindi ba dapat parang magkaroon ng arguments, ibigay nila yung itong bawat senador ang kanilang argumento kung bakit gusto nila o hindi na payagan na itong manifestation?
Entitled sila under the rules. They have been allotted, I believe, 2 minutes each to make comments. But if nobody will manifest that they're interested in making comments, they will just take it to a vote.
Ito, Attorney Joey, this is a legal or procedural issue. Kumbaga technical issue ito na ang magdedesisyon ngayon ang Senado na hindi naman sila lahat abogado. Sa tingin niyo po ba kaya nilang i-handle itong matter na ito? Because the presiding officer cited jurisprudence. Attorney Alan Peter Cayetano also cited jurisprudence, meaning yung basihan nila under the law medyo matimbang. Kaya ba nagpatawag ng recess ito nag-move for recess si Senator Soto?
Sa aking palagay, kaya nagpatawag si Senator Soto ng recess is para maklaro rin niya kung ano dapat ang procedure. Bukod dun sa substantive na kaalaman na kailangang isa-isip ng mga senador. Ano yung procedure? Kasi pag nagpatawag ka ng boto, according to the rules, dapat merong 2 minutes na i-allot doon sa humihingi or nagmo-move for a vote. Pangalawa, merong 2 minutes na ibibigay para sa kanino man na nag-o-oppose doon sa call for a vote. Pagkatapos nun, may 1 minute na ibibigay ulit doon sa humihingi ng vote, no? Pag natapos yung prosesong yun, saka magkakaroon ng botohan. Ngayon, yung substantive naman, gaya ng tanong mo, naiintindihan kaya ng lahat ng senador to kahit hindi sila abogado. Sa aking wari, palagay ko sa paliwanag ng mga senador pag nagkaroon ng itong procedure na to, sasabihin nila, kailangang ipatawag yung son-in-law kasi hindi naman bawal ito. At in fact, may desisyon ng Supreme Court na sinasabing pwedeng ipatawag to para magtestigo kahit na ang kanyang pagtetestifian against ay yung kanyang father-in-law. So, sa paliwanag naman ni Senator Cayetano, tingin ko pinapaliwanag din niya para sa kapwa senador niya. So siguro maintindihan naman ng mga senador.
So kapag pinayagan, let's say bumoto sila at sinabi, okay, patawag natin yung son-in-law, hindi pwede ba din siyang mag-invoke ng right to self-incrimination or whatever na ayaw niya mag-testify na kagaya nung sa ibang grounds na linagay dito, baka masira yung relasyon nila magpapamilya?
Base sa letra ng rules, parang hindi.
Hindi.
Although earlier they used the principle or doctrine of necessary implication, he might want to raise that again. But strictly speaking, it looks like it's not in the rules. I have 2 more points. I think I have to make it or mention it now.
Go ahead,
Si Senate President Enrile kept on mentioning it's akin to a criminal proceeding. Well, true, there are some features that are akin to it, but I would...
But question there, Attorney, why is it important? Bakit importante yung pag-usapan nila yung nature nung proceeding, whether it's criminal, it's civil? Bakit importante yun? Is it going to affect the way they will vote or yung basihan ng kanilang desisyon? Is it a matter of procedure? Why is that important?
Malaking factor yan because a criminal proceeding is always in favor of the accused.
In case of doubt.
Everything, in case of doubt, slanted in favor of the accused. In civil, not so. Yes. So, if the senator judges believe that this is closer to a criminal proceeding, then they will be very protective of the accused, or actually he's not called accused in this case. The Chief Justice is referred to as the respondent. But what bothers me is one of the grounds for impeachment is betrayal of public trust. That was left by the framers undefined, so that the senator judges can define for themselves. And many commentaries have said that it need not be a crime to fall under betrayal of public trust. Talking to a litigant, or
Parang ethics pwede.
acting in a manner that is not with probity, integrity. Those are not crimes. But if you do it in a way that will cause the public to withdraw their trust and confidence in you, you can be
Pero
impeached.
bakit pumasok yung usapin na yan sa stage na ito?
Well, they're only in the information gathering stage. That's why it's surprising. It's so early, and yet there's already fireworks. I really don't know how they will decide. But if they are not allowed to bring them in, then they'll just have to go to their documentary evidence. It will be a little bit more difficult.
Kasi
for the
sinabi nga ni
prosecution.
presiding Justice Enrile na itong pwede nilang they can have other recourses, hindi lang itong pamilya niya, no? Sinabi na nga niya, na-desisyon na rin niya yung pagsabina sa mga city assessors para malaman kung itong properties nga na ito ay nakapangalan kay Corona.
But what the city assessors cannot tell you, or the senator judges, is the motivation behind an alleged purchase. Whether the one who purchased it really had the means. So that would cover maybe the children. Did they have the means to do it? Who's been paying, sino nagbabayad ng amilyar, taxes, o yung mga utilities of the properties. So they might go into areas where it's not the registered ownership that is being referred to, but the beneficial ownership. And for that, you need other people to shed light, give their testimony.
So are you saying na common nakapangalan sa kanya, that does not prove na sa kanya yon? Ganun ba? Bakit, why do you have to have all those other factors?
Well, the issue here, as mentioned by Senator Cayetano, it's relevant to the issue of graft and corruption. So the reason why you bring out the properties is to see if the respondent in this case amassed wealth out of proportion to his income. Now, if it's not in his name, but you feel that he's the one who amassed it or who acquired it as a result of ill-gotten wealth, then you have to inquire if the registered owner is the real owner.
Ang nabanggit ni Senator Cayetano, he doesn't want this to be a precedent or magsilbing na magiging gabay na in their future decisions. Which makes me wonder, dahil sa kanilang mga committee hearings, ang rule is subpoena, and then the witness or the resource person can just claim the right against incriminating himself as the questions are raised. So you think their experience sa kanilang committee hearings, applying that, will probably sway the way they will decide on this issue? Attorney Joey.
Oh, maaaring ganun. Maaaring ganun. Ang isang kailangan lang natin tandaan tungkol dito is that sinabi rin naman ni Presiding Officer Enrile na meron namang ibang paraan para ma-establish itong evidence na gustong i-establish through the testimony of the Chief Justice, the family, and the in-laws. So, yun nga, medyo pinreempt na niya, inunahan na niya, na sabi niya, pumayag siyang mag-issue ng subpoena laban dito sa mga officers ng Land Registration Authority para makita yung mga titulo at kung sinong nakapangalan doon sa mga titulo, doon sa mga properties na binibintang ay na-acquire illegally ni Chief Justice. Ngunit kahit na sinasabi natin ganito na ma-produce naman yon through other means, syempre kung meron kang mga gustong itanong tungkol doon sa mga dokumentong yun.
Kapasidad ng pagbili niya noon.
Eksakto. Hindi mo naman maitatanong yung LRA officer tungkol doon. So, hindi kumpleto yung iyong mabubuong kaalaman o hindi lalabas yung
So, gaano kahalaga na kung mapatawag ang itong son-in-law niya, no? Kasi ang son-in-law, pwede niya sabihin, wala akong alam. Di ba? How will let's say, the prosecutors try to squeeze out from him na kung ano ba talagang inaccumulate ni Justice Corona itong mga properties na to based on kung paano mapoprove nga na merong hindi magandang nangyari doon sa pagkuha niya ng mga properties na yon.
Hindi naman end of the world para sa prosecution. For example, if the question you're interested in is sino na nakipag-usap sa condo developer, sino nagbayad para sa down payment or this or that, you can still ask the condo developer. You can try to get testimony or documents that way. So it's not the end of the world. It might make it more tedious though. But I think there are other means.
Kung sa tingin nyo, yung ito naman, mapunta tayo dun sa, kasi sila Attorney Cuevas, they were prevented from supporting their motion dahil nga inapprove na ng presiding officer, hindi na sila pinagsalita. Ngayon na nag-issue na ng ruling at babalik na rin to put to vote, mukhang based sa rules, ang magsasalita na lamang yung mga senator judges. If you were Attorney Caloy, the counsel for the defense, would you ask for an opportunity to manifest at to support your motion? Dahil mukhang out na sila base sa Section 6 sa attorney na binasa ni Attorney Joey.
You read my mind. I think in a regular court, Justice Cuevas would probably have reminded everybody, this is a settled issue. Why are we even taking it to a vote? The prosecutors have already submitted, so there's no need for a vote. But I don't think he wants to draw the ire of the senator judges. I think everybody can understand that.
So, pabayaan na lang nila. Is that the way to go? Ganon.
Oo, talagang. Kasi, base sa rules, kung umabot na nga sa stage na yun, na out na yung mga counsel, unless they make a request to be allowed to speak, and the presiding or the entire body, you think they would do that, Attorney Joey?
Palagay ko hindi kasi kung ako si Attorney Cuevas, ang motion naman ni Senator Cayetano is for the in-law lang eh. Di ba? Gaano kalaki yung damage na makokos ng testimony ng in-law, timbangin mo laban doon sa, gaya ng sabi ni Attorney Caloy, na baka mapikon yung mga senador sa'yo. Di ba?
Hindi pa kasama din yung asawa at mga anak?
I thought kasama
din ang asawa at anak.
Ang sinabi niya, kung tama ang aking pagkakaintindi, binatikos niya yung desisyon ng presiding officer tungkol sa asawa, sa anak, son-in-law. Pero kung tama ang aking pagkakaintindi muli, ang hinihingi niyang motion na baguhin ang ruling ay tungkol lamang doon sa son-in-law.
Iba yung narinig ko but we'll find out later.
Ang narinig ko is example niya yung sa son-in-law. Mukhang yun yung kanyang exhibit. Pero yun, makikita natin to, lilinawin nila itong pero sa regular procedure ba, ganito ba kahirap? Meaning, sa simula pa lang, wala pa tayong naririnig na ebidensya. Hindi na yung labanan.
No, for the reason that every lawyer is expected to bring as much evidence in favor of his client and his case as possible. You don't want to be accused, or the court would not want to be accused of curtailing that right. But when the witness or the party is asked a question, if it really will infringe on their constitutional rights, the Bill of Rights, for example, then they have every right to not answer.
Pwedeng hindi siya. Kasi does this also apply to him, itong constitutional right because it might put him under strong temptation to commit perjury, kaya hindi niya pinayagan din yung mga anak. Does this apply also dito sa son-in-law? Kapag sasabihin niya, I cannot answer that? Or baka mapilitan siya kasi son-in-law siya di ba?
To a lesser degree, pero tama yun.
Why should the public be patient? Ano ang tinitimbang dito? Dahil para siguro sa publiko, iniisip na, we just want to know the truth. So why are itong mga rights na pinag-uusapan also very important for our democracy as a whole?
I'm so happy you asked that question. I think that right or the right against self-incrimination might be preempted in this case right now. If they decide for the parties, then there will be a question mark whether the truth will come out, can come out, not will, can come out in a situation like this, where we're not even giving a chance to call all the witnesses. So, my hope is that as much evidence as possible can come in, and then let's just decide based on that.
You want to add, Attorney Joey, bakit dapat tayo magpasensya? Dito sa aking pagkakaintindi, it's going to be private rights or rights ng mga akusado, ng pamilya versus the right of the prosecution to bring them into the court. So parang merong dalawang rights, the right for this to proceed and the right also to be protected against inquiry kung meron ka namang karapatang pigilan ito. Bakit kailangan tayo magpasensya?
Siguro ang paliwanag dito na makaka-relate ang taong bayan is lahat tayo gusto malaman ng katotohanan. Pero habang inuungkat natin ang katotohanan, kailangan din na yung mga rights, mga karapatan ng mga tao na panggagalingan nitong katotohanan ay respetuhin natin. May sinabi si Presiding Justice doon sa kanyang ruling na we cannot compel or we cannot force under duress yung mga titistigo na maglabas ng katotohanan sa sapilitang paraan.
Yung ba yung self-incrimination? Paki-explain nga yung term na self-incrimination para maintindihan ng publiko.
Yung self-incrimination, ang ibig sabihin nito, sa iyong pagtitestigo, sa iyong pagbibitaw ng mga salita, hindi ka dapat pilitin na umamin sa kasalanan.
Okay.
Ang pwede lamang gawin ng prosecution is gumawa ng paraan para maghanap ng ebidensya para mapatunayan yung kanilang ibinibintang sa'yo. Pero hindi nila pwede ikaw pilitin na sabihin, ginawa mo ito, hindi ba?
Kagaya nito, no? Siguro yung ibang mga nanonood naiinip na, bakit ganun? Ba't kailangan pa na ganito? Let's get on with it. Ba't may mga ganito pang teknikalidad? Anong kahalagahan na bigyan, pagtuunan din natin ng pansin yung mga ganitong klaseng insidente o teknikalidad para maging maayos yung proseso?
Actually, sinabi na ni Attorney Mark it's the individual rights clashing with the general right to obtain information.
At mukhang the senators are taking some time, Attorney Caloy. Are they consulting their lawyers?
Nagbabasa pa sila ng mga
Their legislative officers and their private counsel.
So, you think we'll be seeing more of this, itong mga technicalities na kailangan pagtuunan nila ng pansin na maaaring medyo magpatagal dito sa proseso?
Initially, yes, but as the trial goes on, hindi na siguro because this is only the second day and they did not have a pre-trial where a lot of the issues would be threshed out. So it's still considered within normal parameters. But if this goes on after several weeks, then it's not normal anymore.
Pero para sa mga abogadong nanonood, mukhang doesn't this look like they're having pre-trial dahil pinag-uusapan na nila kung sinong testigo ang pwedeng ipatawag at hindi? Attorney Joey, anong tingin mo?
Tama ka doon, Mark. Parang kung nagkaroon ng pre-trial conference, gaya nung sinasabi ni Senator Cayetano, sana mas maayos at naiwasan yung ganitong klaseng aberya dahil magkakaroon ng pagkakataon para sabihin sino talaga yung mga dapat na tatawagin bilang testigo at magkakaroon ng oportunidad para magkasundo ng maayos at hindi na sa ganitong paraan na before the viewing public.
And well, for the viewing public, it'd be interesting to listen to what they're talking about right now, ano? Kung paano ba nila pinagdedebatehan ng whether to vote this or that way. Hindi ba dapat ilahat din sa publiko yung kanilang mga diskusyon para makita naman ng mga tao na, ito kasi kaya ito yung binoto ko kasi ganyan. Yung pag-uusap nila, hindi pa kasama yan sa procedures, sa rules, para naman ma-discern din ng taong bayan kung bakit ganito ang napagkasunduan.
Mukhang after this, they might go into the 2 minutes, 1 minute. Attorney Caloy, what do you think?
Yes.
Should they go to that step in the procedure?
It's possible, especially after they had a break. They can educate themselves a little more. I cannot speculate if they're talking among themselves or if they're using the time to read up. But it's fair to say that some might want to manifest their own opinions on the matter after the break.
They have put time limits to the statements of the senators na 2 minutes lang. Pero yung kanilang recess, walang ano dyan, time frame. Hanggang 1 to sawa yan.
Pero maganda, merong diskusyon between a senator judge and the presiding. But how did you find the decorum, Attorney Caloy? Anong tingin mo doon sa the way they handled it? Kasi parang may clash kagad between the presiding at kung titingnan ng mga taong bayan, naku, posibleng nag-aaway yung mga juror. Pero how did it come across for you?
Well, they each gave the other a chance to speak. Nobody was cutting the other one off. So in that respect, you can say that they were acting civilly. But if you read the body language, I think Senator Enrile was a little irked, or maybe he wanted to just get on to the next stage. But it's really not possible in this situation because the Senator Cayetano has raised a valid point, and it's up to the senator judges to decide whether they will give that consideration or not.
What if the senator judges decide na since mabigat nga itong legal issue, huwag muna nating desisyonan ngayon. Ipagpabukas natin, give us time to study this, ipagpabukas. Can this trial still proceed today on other matters? Attorney Joey, sa tingin niyo?
Pwede naman. Pwede namang mag-proceed sila on the basis of the other subpoenas na i-issue ng presiding officer. Lamang napaka-importante kasi nitong issue na to. Kaya tayo siguro nagtatagal o kaya nagtatagal yung mga senator judges kasi this will determine to a large extent kung ano yung maiprepresenta at may lalabas na ebidensya laban dun sa ill-gotten wealth ni Chief Justice Corona. And siguro ganon katimbang itong ground for impeachment na the prosecutors chose it twice to initiate their arguments on the basis of this Article 2. So ganun ka-importante. Kaya siguro talagang pinag-iingatan nila, tinitimbang ng mabuti ang kanilang mga remedyo para magawan ng paraan na may labas talagang katotohanan sa issue nito.
At isa pa dun sa mga subpoena na pinapa-issue ng prosecution team, itong kay BIR Commissioner Kim Henares, no, para naman sa buwis. Ito ba mabigat din? How will this impact on the case?
Well, that's from a visual point of view. Seeing the BIR commissioner testify, we will really grab you.
Pero alam mo naman dito sa Pilipinas, minsan hindi naman honest sa pag-file ng income tax return. How can you, hindi ba?
But she can testify on other things, whether taxes have been paid at all and by whom. Never mind the amount. Some of the that's why the prosecution, it's hard, even though they theoretically they can do other things. I'm sure the prosecution would want to know what the final decision on this issue right now will be, because it will alter the way they prepare their evidences. They don't know whether they have to present these witnesses or not. That will hamper their efforts.
Dito pala sa pagpresenta ng mga properties, sinabi nga 45 properties, no? But there are some na yung mga properties na yun, let's say, yung 3 parking lots dito sa isang condominium, counted as 3 properties. So, naging 4 na yun, yung condominium plus yung 3. Kaya daw naging 45. Is that right? Ganun ba yung nangyari?
I don't think they're denying it. In fact, if I remember right, in one of the press or briefings of the prosecution team, they mentioned that a parking lot alone will cost something in the vicinity of 2 million pesos.
Wow, parking lot lang yun na 2 million.
Because the smaller the area, the more expensive in those prime areas like Taguig. So even if it's a parking lot, that's counted as one. A parking lot can actually, technically, it can cost more than a house in another area. So that's why they included, I think.
In the last impeachment trial of ERAP, dahil daw doon maraming naging abogado, daming nag-enroll sa law school. Pero in this instance, attorney, ang sinasabi ni Chief Justice, we're ready to explain na wala kaming tinatago. And yet, lawyers are saying now na hindi namin ipipresenta itong mga anak, itong mga kapatid. So, how is that consistent dun sa statement na yon? And are lawyers just making it difficult or just they're on their rights to do that?
Well, it's where you draw the line in the sand. If your rights are being trampled upon too much, as a lawyer, I would be the first one to say that the individual should already invoke certain privileges. But if those rights are really just being used as a delaying tactic to muddle the issues or to complicate matters so that the truth cannot surface anymore, then that's the wrong way to use your personal privileges and rights.
There have been instances na may mga kasong nadi-dismiss by mere technicality na even if like everybody knows the person did it, pero dahil sa technicality teknikalidad, nakakalaya yung tao, hindi ba? How can you prevent that from happening here by mere technicality? Hindi, how do you do
Well,
that?
a lot depends on the senator judges, the presiding officer.
As we're looking at the screen, the senator judges walking back into the hall. Alam niyo po, i-describe ko lang, there's a Senator Pimentel. Coco Pimentel is a bar top-notcher. Si Senator Alan Peter Cayetano, Senator Pia Cayetano are partners in their own firm. Senator Kiko also a partner in his own firm. Joe Arroyo is a lawyer. These are people trained in law at sa tingin natin ay kayang-kaya nilang desisyonan ng in the best way possible
But
itong
they would
kaso
have
nito.
to explain it to the others who are not lawyers. Only 11 are lawyers sa mga senator judges natin. No? For example, like Senator Lito Lapid is into the movies, Jingo Estrada, hindi sila lawyers eh. So, kailangan maintindihan nila itong mga technicalities na ito, hindi ba?
May mga abogado sa kanilang legal staff, mukhang they should be
Overworked
properly
na.
guided. Mukhang overworked na sila, no?
Pero mukhang smiling faces ang pagpasok nila, no?
Wala pa
Mukhang
sa
relaxed naman sila, no?
Wala pa sa hall ang ating presiding officer. Hindi po magsisimula yan kung hindi po babalik si Senate President Juan Ponce Enrile at ang kanyang ibabang na naman uli ang gavel. Yan po ang magsisilbing signal na nagre-resume yung kanilang session. Ayan po,
Ayan,
nakikita
wala pa
natin
siya,
yung
no?
gavel ni Senator Juan Ponce Enrile. Yan po yung simbolo ng kanyang authority.
At inaasahan natin na nakapag-diskusyon na sila, deliberate na sila dito sa issue na ni-raise ni Senator Alan Peter Cayetano at magbobotohan na sila dito.
Senator Chis Escudero is also a lawyer. Senator Franklin Drelon topped, I think, number 8 in the bar exams of his batch. Kaya merong mga legal minds
And
na sa Senado.
we would like to see whether diretso ng botohan o di kaya magdi-discussion muna sila, magkakaroon sila ng mga 2-minute statements. And if the defense will also be allowed to
Support their motion.
Yes.
Kasi mukhang kahit na as it stands, na-approve yung kanilang motion, mukhang mababaliktad. Hindi dahil sa objection ng prosecution, but dahil dun sa manifestation ng isang senator judge na nagsasabing, may konting problema ako sa ginawang ruling ng ating presiding officer.
And what bearing will itong ginawa ng prosecution na nag-submit na sila, what bearing will it have on this particular itong gagawing mangyayari ngayon?
Ulitin
Ano?
lang natin, as I remember it, ang motion is for the decision to be amended. Now the session resumes. Let's watch this.
An issue has arisen because a request for a subpoena duces tecum and a subpoena testificandum against Chief Justice Corona, his wife and children and son-in-law were requested, and the chair ruled to deny the request. The prosecution indicated its conformity with the ruling. Nevertheless, a member of the chamber of the Senate objected, in effect, to the ruling of the chair, and so the chair asked the member of the Senate whether he wanted the House to be divided. And the chair has decided to divide the House in order that the matter be decided by the Senate sitting as an impeachment court. As I said beforehand, I'm not the court is the Senate. And so therefore, I will now ask for a division of the House on this issue. And so I ask the Secretary to call for a vote.
All those in favor of the ruling of the chair say ayes. Not in favor, and those not in favor of the ruling of the chair say nays. Okay.
What is it?
About raising of the hands. All those in favor of the ruling of the chair, raise your hands. Please count. taken? Okay. Those not in favor of the ruling of the chair, raise your hands.
What is the result of the voting?
So 14-6, 14 in favor of the ruling of the chair, 6 not in favor.
So the ruling of the chair is sustained, and so it stays as a ruling of the Senate.
Thank you.
Adjourn to
Mr.
floor
President.
leader.
Thank you, Mr. President. Yesterday, January 16, 2012, the Counsel for the Chief Justice filed a motion to disallow appearance of a private prosecutor, praying that the Honorable Impeachment Court disallow the appearance of Messrs. Mario Bautista et al. As private prosecutors, there being no compelling justification for the same. So, Mr. President, I move that the presiding officer rule on the motion.
With due respect to the defense, the chair rules that the request is not in order because the rules of the House allows the presence of a private prosecutor to assist the panel of prosecutors designated by the House of Representatives. It is a matter of rule and a matter of precedence. So ordered.
Mr. Senate President, please.
The gentleman from Iloilo.
Yeah, may we be allowed, Mr. Senate President, just to make a very, very short manifestation.
Proceed.
A few minutes ago, Mr. Senate President, Your Honors, after the explanation by the Honorable Senate President, the prosecution submitted to the ruling with respect to the denial of the request for the issuance of subpoena. However, with due respect to the Senate President, we just want to put it on record, Your Honors, that the prosecution take exception to the statements, specifically that, and I quote, the proceeding is akin to a criminal case, and another one is that it is in the nature of a criminal case. With due respect again, Mr. Senate President and ladies and gentlemen of the Senate, it is the position of the prosecution that the impeachment proceeding is not akin to a criminal case, nor is it a proceeding in the nature of a criminal case, but our position is that the impeachment proceeding is sui generis, or it is like no other. And in this regard, may we be allowed to submit a legal memorandum with respect to this issue, Your Honors, please. Thank you.
But I would like it, to read into the record the reason why the chair has stated that it is akin to a criminal case. Just for the record. An impeachment case is not a civil case, nor is it a criminal case. It is sui generis, a class by itself. But it is closer to a criminal case than a civil case. In a civil case, the parties, both the plaintiff and the defendant, are normally private persons. And the subject matter of the case is usually a legally demandable and enforceable right which carries no punitive sanction. In a criminal case, the direct complainant is the people of the Philippines, and the case invariably involves a legally punishable conduct which carries a punitive sanction, like loss of freedom or imposition of economic burden. In an impeachment case, the people of the Philippines are only indirect complainants. They delegated in their constitution the exclusive power to initiate all cases of impeachment. they delegated it to the House of Representatives composed by their elected representatives. An impeachment case carries a punitive sanction which is limited to the removal from office and disqualification to hold any public office under the Republic of the Philippines by the official charge. The criminal character of an impeachment case is exemplified by the fact that the person charged has to be informed of the charges against him, that he has to plead guilty or not guilty to the charges, and that, quote, the party convicted, this is section 3(7) of the Article 11 of the 1987 Constitution, shall nevertheless be liable and subject to prosecution, trial, and punishment according to law. I just want to put that into the record. That is the opinion of the presiding officer. Majority Floor Leader.
Yeah, Your Honors, may we just ask what's the source of the material just read by...
This is the product of my own mind.
Okay. Thank you, Your Honor.
Majority Floor Leader.
Thank you, Mr. President. We are now ready for the presentation of evidence by the prosecution.
This prosecution may proceed.
The prosecution, Your Honor, is ready to present its evidence, and as provided for in the complaint, we shall start presenting evidence insofar as Article 2 is concerned.
May we know why you're changing the sequence of your articles of impeachment?
If Your Honor, please, it is a basic truism insofar as the practice of law is concerned that a party presenting evidence has the power to determine what would be the order of presentation of evidence. In the complaint, there are 8 articles pertaining to impeachment. And insofar as Article 2 is concerned, it deals with the sullen, with the ill-gotten wealth of the respondent. And this issue has been the subject of discussion before the media. No less than the respondent has stated that he owns only 5 properties. On the other hand, there has been an allegation that there is a claim...
Wait a minute, Counsel. The chair, the presiding officer is asking, may you please state why you are changing the sequence of your articles of impeachment?
Yes, that's why may be permitted to complete. Firstly, Your Honor, I have stated that the party presenting evidence as a basic rule has the right to determine what would be the order
But
of
the court
presentation.
can also state otherwise.
Yes, Your Honor.
Correct.
That's why we are justifying why we want to present evidence on Article 2. Secondly, Your Honor, there has been so many news releases insofar as the sullen and ill-gotten wealth issue are concerned. And therefore, it would be the best interest of the parties as well as the public for us to present evidence insofar as this issue is concerned. There has been claims regarding the properties of the respondent. There has been an allegation that even the Chief Justice is willing to donate the properties to the victims in Cagayan de Oro. And therefore, in the highest demand of public interest, in order to settle this issue, we want that we be allowed to present evidence insofar as Article 2 is concerned.
Is it true? Counsel? Is the counsel true?
May,
No, I'm asking if the gentleman is finished.
Yes, Your Honor.
All right, what is the pleasure of the defense?
thank you, Mr. President. We are not in total conformity and in full accord with the statement of the Honorable prosecutor, Your Honor, for the simple reason that while it is true that the prosecution or the prosecuting officer can determine the order of presentation of his witness, that is merely discretionary and not a matter of right. There is never any jurisprudence on the point that will point to the fact that it is an exclusive privilege and absolute at that, because it is subject to the discretion of the court. Now, we are wondering why there will be an alteration in the manner of presentation of evidence, Your Honor. We were served with a copy of the impeachment complaint. There are 8 grounds therein stated. We wanted to believe that any and all grounds will be the subject of the evidence of the prosecution in the manner they are stated or appearing in the articles of impeachment. Why the deviation? Now, there is an allegation to the effect that there is a demand, public opinion, and so on, a newspaper. It is very clear, Your Honor, that in this kind of proceedings, we are totally disregarding public opinion. We are totally disregarding what the press states, Your Honor. But in accordance with the oath of the members of this honorable body, Your Honor, it is stated that what should govern the ruling of this honorable impeachment court will be the conscience of these members thereof, but in accordance with the provisions of the Constitution and the law. Now, if we subscribe or allow the introduction of this kind of evidence, then this impeachment court will be at the mercy of the prosecution, Your Honor, which can never be the philosophy nor the reason behind the requirement of procedure insofar as trial is concerned. I do not see any reason why they cannot proceed with number 1, with and so on down the line, and instead choose number 2, Your Honor. First, if there are witnesses right now, Your Honor, may we place on record that we have never yet been identified with the identity of this witness. As a matter of courtesy, Your Honor, we were expecting that we will be granted at least 3 days within which to be informed of who these witnesses are, so that we can prepare for an intelligible cross-examination. True, we may cross-examine, but if it is not intelligible, if it is not in accordance with the procedure and the law, Your Honor, then it will be an exercise of futility. There is nothing that this impeachment court could get from that, not any enlightenment, but rather confusion, Your Honor. We wanted to avoid that kind of an eventuality.
Is the prosecution ready to present evidence on Article 1?
Well, we are not ready, Your Honor.
You
But
are
may
not
I just
ready.
make a rejoinder, Your Honor? We are ready for Article 2.
You are not ready to...
We are ready for
you are
Article
not
2.
Wait a minute. You are not ready to present evidence on for your Article 1?
We prepared for Article 2, Your Honor. And may I just make a brief rejoinder to the statements of the counsel for the defense.
You have 2 minutes.
Yes, Your Honor. Firstly, we do not want public opinion to be the issue insofar as SALN is concerned. As a matter of fact, no evidence has been presented, and yet there has been press releases regarding the ownership of this property. It is for the best interest of the parties, especially the impeachment court, if we settle the issue pertaining to the evidence regarding the SALN and ill-gotten wealth. Counsel for the defense also stated that we did not give them the opportunity to identify our witnesses. We have to state, Your Honor, that there has been no pre-trial insofar as this case is concerned. Moreover, Your Honor, the defense has submitted so many pleadings, objections to the subpoena, things like that. If they really want that they should be notified or be informed of the witnesses, they could have filed the appropriate motion insofar as this request is concerned.
Is the gentleman true?
Yes, Your Honor.
Just for the record, then if you consider Article 2 as the most important part of your articles of impeachment, why did you not make it as your number 1 article?
Well, we consider, Your Honor, that all articles in the impeachment are important.
They are in pari passu.
Yes, Your Honor.
All right. The gentleman from Makati and Bicol.
Thank you, Mr. President. I don't think we can limit the presentation of the articles on the part of the prosecution. I have once been a prosecutor. And sometimes we have witnesses, sometimes we don't have, so we arrange it. And that is what happened in the Estrada impeachment. But to solve this problem, may we request the prosecution to now rearrange the presentation of the prosecution's evidence, and that would help everyone, so that we would know also on the part of the Senate, we will know what to study beforehand. So if you can rearrange it, I think it will be for the good of all.
For orderly proceeding, I think the suggestion of the gentleman from Makati and Bicol is well taken. And if I may request the prosecution to rearrange the order of your articles of impeachment in such a manner that the defense is forewarned, so that we can also help the staff of the impeachment court to prepare for the succeeding hearings.
Besides, Your Honor, may we be allowed to make a short manifestation, Your Honor?
Proceed.
Alright. Besides, Your Honor, there is abundant jurisprudence to the effect that in the filing of any charge involving a criminal offense, the prosecutor must already be in possession of the evidence against the accused and not gather the evidence after filing the information. That is a contempt procedure. It is violative of the rule on due process, Your Honor. Now, they say that this is the subject of the talk of the town. This is what appears in the. This is what had been discussed by the press and the media. Because they always deal with it, not knowing that there is a rule that should be followed in the matter of presenting evidence.
We take note of that, Counsel, and I think that for us to proceed, may I now request the parties to prepare for trial, and let's finish this manifestation and counter manifestation and go on into the nitty-gritty of presenting the evidence.
Yes, yes, Your Honor, and thank you very much for that accommodation. We are prepared to cross-examine any and all witnesses they'll be presenting under impeachment, under the first article of the impeachment complaint, Your Honor. Because that is how we understood the rule of procedure. Thank you very much, Your Honor.
Proceed, Counsel. You may proceed to present your evidence, but kindly state for the record the rearrangement that you want in the presentation of your evidence henceforth with respect to the 8 articles of impeachment.
Well, so right now, Your Honor,
so that we can also guide the clerk of court and the staff in an orderly recording of the proceedings.
yes, Your Honor. Right now, we shall be starting with the presentation of evidence insofar as Article 2 is concerned, and tomorrow we'll be filing a written manifestation regarding the order insofar as the presentation of evidence for the other articles are concerned.
So ordered. Call your first witness.
If Your Honor, please, may we be allowed to make a short comment, Your Honor?
Yes, you have 1 minute. Short
Thank you, Your Honor. That's more than enough. All the while we were agreed on the proposition that the order of the presentation of their witnesses or evidence, Your Honor, will be in accordance with what is stated in their complaint. We prepared for that, Your Honor. Even in our answer, we deal with the allegation one by one. 1, 2, 3, and 4. Now, they say they are not prepared to present their witnesses under number 1. What is there to prevent us, Your Honor, in stating for the record, very honestly and sincerely, that we are not prepared for number 2 because we were expecting that they will be dealing with number 1.
Counsel, I'm sure that you have prepared your trial brief, and I'm sure you can handle the prosecution and meet their request by using your trial brief.
Yes, Your Honor, but may we be allowed to state, Your Honor, the trial is a battle of legal minds, Your Honor, opportunities and so on. And for that reason, Your Honor, we want to manifest and confess on record that we are not ready insofar as the evidence for the article number 2 is concerned. So that's why we come before this honorable court, if not in bended knees, but a plea that that the presentation of their evidence be centered or gravitate on the first article
Are
of
you
impeachment.
objecting to the request of the prosecution to start with number 2?
Definitely, Your Honor. With due permission and with due regard, and if we apologize for this manifestation, Your Honor, because as we have stated, when we were discussing this even with the panel of defense lawyers, Your Honor, we were dealing with Article 1 as the priority article that will be dealt with in the presentation of their evidence, Your Honor.
Well,
If Your Honor, please, insofar as the evidence to be presented this afternoon is concerned, we will just be presenting certified true copies of the titles to the property of the respondent, as well as the corresponding documents, such as the deed of absolute sale, which became the basis for such titles. As a matter of fact, inasmuch as they are true, certified true copies, I don't think, without being presumptuous, that the defense counsel would be having a cross-examination. We will just be proving that the respondent are the owners, that the respondents are the owners of the properties on the basis of the record of the Land Registration Authority. That would be all.
I do not know what kind of
just a
evidence.
minute.
I'm sorry, Your Honor, and I apologize.
Just a minute. Are you presenting testimonial evidence to accompany the presentation of your documentary evidence?
Well, we shall not be presenting any testimonial evidence. We shall be presenting certified true copies, and this is permitted under the rules of court, considering that the documents which we have to present happen to be public records.
Who will testify on the signatures of the parties who are certifying on this document?
Well, if it is a computer-generated, Your Honor.
Wait, Maurice.
Computer-generated documents. And I think the defense counsel would agree that under the present procedure, insofar as titles are concerned and supporting documents, the computer-generated copies are the certified true copies.
What is the...
We would not like to discuss on that point, Your Honor, because we understand, in accordance with the rules of procedure and evidence, and even in accordance with the rules of impeachment, before this honorable impeachment court, we have the right to cross-examine. So whoever witness they may want to present, whatever documents they may have in mind in presenting, Your Honor, we will never be deprived of the opportunity to cross-examine, because that will be violative of our right to due process, Your Honor.
Let me understand the position of the gentleman from the prosecution side. Are you just asking for the marking of these documents, or are you submitting them as evidentiary material already in this proceeding?
Evidentiary material, Your Honor.
Because if you will submit this as evidentiary material, then this chair will have to rule on the admissibility of this document.
Well, anyway, Your Honor, as we understand, the court has already issued subpoenas to the Register of Deeds, to the Land Registration Authority.
Why can you not wait for the Register of Deeds to bring?
Yes, Your Honor. That's why I am manifesting that we are willing to postpone the hearing for today. And
yung pala ang gusto mo i-postponement.
no, actually, Your Honor, I was toying the idea that in order to expedite the proceedings, they would be willing to accept these computer-generated documents. After all, these computer-generated documents are in the names of the respondents.
Your Honor, with your apologies.
Wait a
I'm sorry,
minute,
I'm sorry, Your Honor.
Just a minute. I have practiced a long time ago, and I'm not used to computer-generated documents. What I understand under the rules of evidence is that any document presented in a courtroom
Must be
authenticated,
This is no
and
longer
the basis for the presentation must be laid. In other words, the predicate must be laid first. Correct?
actually, Your Honor, during the time that I was also practicing, that was the procedure. But now, insofar as the LRA records are concerned, we have the computer-generated documents which are in the security paper of the Land Registration Authority with a barcode.
Well, anyway, at any rate, in order to cut short this discussion, we will come to that time when we will either rule the admissibility or non-admissibility of your documents. And I warn you that unless the chair is satisfied that these documents are authentic, and unless you present the custodian of this document and testify on the presence of these documents in the computer, then the ruling of the chair might be adverse.
Yes, Your Honor. Thank you very much for that ruling.
Not ruling, but a warning.
Yes, Your Honor. The ruling that we have the obligation to properly identify under the rules of evidence at the proper time.
But what is your pleasure now?
We shall start with...
You want to proceed or you want to postpone?
We'll just have it postponed, Your Honor, to avoid further arguments and in order to afford the defense counsel the opportunity to prepare for tomorrow's hearing.
The gentleman from Aurora.
Yes, Mr. President. I thought we want to go back to the previous question. I thought the arrangement being suggested by Senator Arroyo, that since the prosecution is going to redo and reschedule the presentation, we will have today, at least we'll hear from them, the sequence of presentation to assist all parties, the defense as well as us, so that our staff can study the sequence of presentation. But now we're back again to debating whether we begin with Article 2. And now we are confronted with the fact that we are not prepared even to listen to Article 2. So can we now, Mr. President, so that this afternoon will not be complete disaster and loss, can we now ask for that previous agreement that the prosecution will present to us now a new calendar of presentation, so that tomorrow we will be ready, our staff will be ready, as well as the defense will be ready. And perhaps, Mr. President, Mr. Chairman, you may want to call for a 5-minute recess so that the prosecution can get together and agree on the...
The trial is suspended for 1 minute, 1 long minute.
Alright, nakita natin, nagkaroon ng medyo debatihan dito sa session hall. Itong sinasabi kasi ng prosecution team, gusto nilang iuna itong article of impeachment number 2 na kine-question naman ng defense dahil sinasabi nila dapat chronological. Pero ano ba talaga ang ruling dito?
Ang standard practice sa court proceedings, kung ano yung hinain mo na order ng presentation ng iyong grounds for charging the respondent, yun ang normally susundan mo. Pero dito naman sa proceeding na to, dahil impeachment trials are sui generis, no? Or ang sinasabi nating in a class of their own. Hindi mo naman talaga kailangang sundin yon sa lahat ng oras. Merong konting leeway or margin ang tribunal or ang presiding officer in this case para payagan na ang prosecution mag-present in the order na kanilang tinitingnan na pinaka nasa ayos.
Nakita natin na si presiding Senator Enrile ay medyo lenient. Is this good, Attorney Caloy?
Lenient in what
Lenient
issue?
dito sa pag-intindi dito sa ginagawa ng prosecution. At mukhang medyo may konting sablay ng konti dun sa kanilang mga sinasabi, pero nakikita natin na lenient. Is this good?
That's good. He's allowing everybody to say their piece. He's just limiting the time, but everybody can talk. But as you can see, when there are many cooks, sometimes it spoils the broth. So there are many ideas, and he has to navigate the entire impeachment court. But if I may be allowed to go back to your original question, in my experience in court hearings, normally the judge doesn't really care how you present your evidence because it's precisely prosecution's evidence. You present it any way you want. You're trying to convince me. So they're not really expected, although usually they do it, they're not expected to follow the order of the grounds as stated in their complaints. The other reason is provided by Attorney Joey that this is an impeachment court. So all the more we should be flexible.
Yung nangyaring walang testigo pero meron silang dokumento. Can you explain, Attorney Joey, anong nangyari doon sa sinabi ng prosecution nga na wala silang testigo pero meron silang dokumento?
Ang sinasabi ni Congressman Barzaga is that ang iprepresenta lang nila ay yung mga documents mula sa Land Registration Authority na magpapakitang nasa pangalan ni Chief Justice Corona at ng kanyang mga pamilya at kamag-anak itong mga properties. Pero again, sa court proceedings, bago mo maihain ang mga dokumentong ganito, normally merong kailangang mag-identify dito sa mga dokumentong ito. Lalo na ang sinasabi ni Congressman Barzaga is that these are certified true copies. So dapat ihain mo rin kung sino yung nagse-certify na tunay na kopya.
So kung ito yung mga titulo, sino ang dapat mag-identify or mag-certify nitong mga to?
Well, in this particular case, dahil meron silang tinatawag na witness dapat, mula sa Land Registration Authority.
Mr. President, may we now
ito dapat
recognize
yung,
the prosecution panel to manifest.
Certify na true copy ito mula sa LRA.
Let's go back to the floor.
In view of the circumstance where we are in, and in view of the perception of the presiding officer of this court that the prosecution is not prepared to present evidence today, the court motu proprio postpones the trial until tomorrow afternoon at 2 o'clock. So ordered.
Okay, narinig na natin, so
Tinapos
postpone
na.
bukas na, after itong motion ni Senator Angara na sana meron ng calendar of presentation para mas orderly yung presentation. Pero ito ba, you think, kaya nagkakaganito, dito pa lang medyo nagkakagulo na, dapat nagkaroon ng pre-trial conference muna para maliwanag yung presentasyon ng evidence and all that?
Malaking tulong sana kung nagkaroon ng pre-trial conference dahil may identify mo na kung sino yung mga witness na iyong iprepresenta, kung yung mga ebidensyang ihahain mo sa tribunal, at magkakaroon na rin ng tinatawag na marking of evidence. Makikita mo na kung ano yung mga documents na iprepresenta mo para pag dumating sa trial mismo, ang gagawin na lamang ay tatawagin yung witness na may kapasidad para magpatunay na ito ay mga tamang dokumento.
Gusto ko lang tanungin din, ito ba kagaya niya, pagpresenta ng evidence, nasa rules of court ba na hindi pwedeng magpresenta ng evidence ang private prosecutor? Kasi in this case, ang hindi ang nagpresenta ay si Representative Barzaga, no?
Sa rules ng impeachment.
Oo, sa rules ng impeachment, I'm sorry. Pwede ba yung private prosecutor na tumutulong sa kanila ang mag-present nitong ebidensya?
Ang basihan siguro ng sagot dyan ay yung sinabing ruling kahapon ni Presiding Officer Enrile na ang gusto niyang mangyari when it comes to argumentation, yung pakipagbalitaktakan, ika nga, ang magiging may karapatan na gumawa nito ay ang public prosecutors, yung ating mga kongresista. At tungkol naman sa mga bagay na ukol sa ebidensya, pwedeng ang private prosecutors ang
Bakit in this case, yung private prosecutor ang
inamin ni Attorney Congressman Barzaga na matagal na siyang hindi nag-practice at medyo siguro kinakalawang na siya. Nga, magandang katanungan yon kasi tinanong din natin kay at Congressman Tanyada kanina kung plano ba nilang i-raise yung issue na ito, kung kailan pwedeng payagan yung private prosecutor. You think it's after what happened this afternoon, kailangan na nilang i-raise yun, Attorney Calon?
I think it's important for them to raise that because they do not want to be bogged down on the small details of procedure. Their objective is to prove that the respondent is guilty, is unfit for the position for very specific violations. Now, if they cannot get around these procedural matters, then that's going to hurt them in the long run.
But mapapagod si presiding officer to deal with these little things.
Yes. You never want to give the judge the impression that you're not prepared for your case. In the courtroom, the judge will always ask, counsel's ready? So you have to say, counsel is ready. And that means if today you're supposed to present evidence, you're expected to have your witness ready, your documents ready. Now, I might be a little bit more forgiving because this is an impeachment process. And I think since this is the second day, maybe people can give Congressman Barzaga some leeway because truly, this is in a class of its own, and you have to strike a balance between the rules of court and rules that are being made up along the way.
As they go along.
Maybe he was of the impression that it need not be strictly in accordance with the rules of court, that the document must be authenticated, must be identified, relevance must be shown by the witness, because a seasoned trial lawyer would be in the best position to bring that out.
And si Senator Angara specifically pointed that out na ngayon nga na sinabi nilang binabago nila, sapat na for this day sabihin nila kung ano nga yung kanilang schedule of presentation of evidence. Siguro, shouldn't they have expected that? Dahil kaka-issue nga lang nung subpoena eh. How can you expect the concerned government officers to come and testify hindi pa nga siguro sila nakatanggap nung kanang subpoena? Attorney Joey?
Tama yun, Mark. Siguro, kaya hindi rin ganun nakapaghanda ang prosecution in terms of inviting the subpoenaed officer to help in marking and identifying and attesting to the trueness or pagkakatotoo ng kopya ng certificate of title na kanilang ihahain. Siguro, ang isang maganda ring tandaan is balik ako sa katanungan kanina ni Nikki, total ito naman ay tungkol na rin sa paghain ng ebidensya. At ayon doon sa binanggit ni Presiding Officer Enrile kahapon, when it comes to matters of presenting evidence, pwedeng pagsalitain o paharapin ng private prosecutor. Hindi kaya maaari na bukas pag nag-resume tayo, hayaan lang
Bautista na ang magpresenta, for orderly
sa
presentation.
Tama yun.
Kasi lahat naman sila gusto nila wala nang, hindi na ma-delay itong proseso, no? So, that would be a good move kung ganun ang gagawin. But, dito sa pagpresenta ng evidence, like for example, yung unang pinipresenta niya ay yung itong sinasabi niyang computer-generated, pero may barcode at galing, parang may security tags ito ng Land Registration Authority. This is admissible. Pwede ito, but it has to be authenticated.
I'm not sure, Nick,
ba?
kung yun yung kung yung computer generated ay may barcode. I think ang minention
Sinasabi
niya
niya.
yung mga titulong dati niyang pinipresenta, sapat na basta may barcode at nasa security paper. Pero mukhang si Senator Enrile, sabi niya, hindi pa daw siya old school pa daw siya, kaya niya yung computer generated. Pwede bang yung presiding magsabi siya na hindi sapat sa akin or hindi ko tatanggapin yung klaseng ebidensya na yan? Makikita ba natin na yung presiding will make rulings on the admissibility or ano yung tatanggapin ng korte na ebidensya of dokumento?
Definitely. Under Section 6 of the Senate rules, it's really the presiding officer who will pass upon that, who will decide on that. But the senators, senator judges, if they want to take it to a vote, they can make a motion to that effect.
Kasi posible ngang merong objection kung ano yung pwedeng tanggapin at anong hindi pwedeng tanggapin, ano?
And the Senate President Enrile already mentioned that I am not the Senate, and the Senate is not me. So he is conscious of that fact.
Pero okay, presenting something like this, you were saying earlier on, na kailangan merong mag-authenticate nito. Pero yun muna ipipresenta, tapos magpapasabina pa sila, hindi ba? At sinabi na nga na pinayagan na itong pag-issue ng sabina dito sa mga city assessors. So that is the next step, hindi ba? Paano ba? How does it go?
Well,
Parang which comes first?
These are a lot of activities that have to be coordinated. I trust that in the future hearings, when they have the documents that they want to present, they will also have the witnesses who will identify the documents on hand. So there's a lot of coordination involved.
Nick, Attorney, let's just get an update kung anong nagaganap sa area kung nasaan si Zarina. Zarina?
Sabay ng pagsisimula ng impeachment proceeding dito sa Senado ay umulan dito sa labas kung saan ito pero natuloy payapa ang labas ng Senado at kung nakita matunog nga ang salin ni Chief Justice Corona. At ito nga yung article 2 na tinatalakay kanina sa proceeding dito sa impeachment court. Tinutukoy nito ang hindi pa sa publiko of asset and liability net worth ni Chief Justice Renato Corona. At pinangungunahan naman ni Pangasinan 6 District Representatives din ng kanilang mga ari-arian, yung controversial.
Alright, thank you, Jarina. No? Gusto ko lang balikan.
Technical.
Oo, later. Babalikan natin, no? Meron tayong audio problem lang doon. Balikan natin siya mamaya. But I would like to ask about this, yung si Representative Neil Tupas. Sinabi niya he wants to take exception dito sa sinabi ni Presiding Officer Enrile patungkol dito sa proceeding na it is akin to a criminal case. Sabi niya this is not so. And it is in the nature of a criminal case. Sabi ni Neil Tupas.
Mukhang na-predict nga yun ni Attorney Caloy.
Bakit ano ba ang significance nito? Bakit kailangan i-point out ni Representative Neil Tupas yun?
Malaking bagay yan. That point is worth debating because if they can win this point, it will slant the case in their favor or it can go against them. In a criminal case, you are either imprisoned or subject to fine. Here, the penalty is removal. And disqualification. So right away there's a difference. The grounds have to be in criminal, it's under the revised penal code or in a special law. So that's why it's a crime. But here it need not be a crime. The causes for removal can be for something that's just not proper. It's not befitting the office, the high office. And that causes people to lose trust in the individual. The other one, very important, is the quantum of evidence. If it is akin to criminal, then that is tantamount to saying that you will protect the rights of the accused, and the quantum of evidence for a criminal case is proof beyond a reasonable doubt, moral certainty. There can be no mistake. But this is contrary to what was mentioned by Senate President during yesterday's hearing, that the quantum of evidence will be convincing and sufficient and convincing evidence, which is probably closer to substantial evidence as found in administrative cases. So that's a there's a word
And
of a
this is
difference.
important enough for them to submit a memorandum at hindi lamang nila i-manifest. Talagang susulat nila para mabasa ng lahat ng mga senator judges. Pero ngayon, Nick, balikan muna natin si Sarina. Mukhang okay na daw yung kanyang linya.
Sarina?
Kasabay nga ng pagsisimula ng ikalawa araw ng impeachment proceeding, umulan dito kanina sa labas ng Senado, pero nakikita nyo namang humupa na at patuloy pa rin nagiging payapa ang labas ng Senado. At naging matunog nga ngayon ang salin ni Supreme Court Chief Justice Renato Corona. At yun nga yung Article 2 na kung saan ay tinutukoy nito yung hindi pagsasapubliko ng Statement of Asset, Liabilities, and Net Worth ni Chief Justice Renato Corona. At dahil nga dito pinangunahan nito ni Pangasinan 6th District Representative Marlene Agabas. At dito nga hiniling o una na nito hiniling ng prosecution na padaluhin ang pamilya ni Corona sa pagdinig dito sa impeachment court, maging ang pagpapadala ng dokumento ng kaugnay sa kontrobersyal na ari-arian ng punong maestrado at ang income tax returns ng mga ito hanggang 2011. Ngunit, idinenay ito ng impeachment court dahil ito daw ay paglabag sa constitutional rights. Base raw kasi sa Article 3 ng 1987 Constitution, there shall be no person be compelled to testify against himself. Nilinaw din ng Senado na oras na sakaling ma-convict si Supreme Court Chief Justice Renato Corona ay mapapatawan siya ng penalty na pagkakatanggal sa kanyang posisyon at hindi na muling makakahawak pa ng kahit anumang katungkulan sa gobyerno. Balik sa inyo, Nikki and Mark.
Maraming salamat, Zarina.
Sarina.
Balikan natin yung ating dalawang legal experts. Mukhang nag-i-enjoy ang lahat sa panonood dito, ano? At mukhang yung mga legal maneuvers.
At saka dami nating natututunan, no?
Yung si Attorney Cuevas, importante pa rin ba yung kanyang mga argumento, mga assertions? Minsan yung halimbawa, dun sa matter on kung meron bang karapatan yung prosecution na mag-arrange nung kanilang gustong ipresenta, nagsalita pa si Attorney Cuevas. Sa tingin niyo po ba, importante pa yun? Attorney Caloy?
Sa palagay ko, it's part and parcel of trial lawyering. You know, one big part of trial lawyering is one-upmanship. You have to show to the judge, in this case the judges, that you know what you're talking about. And you know, he's a veteran at this, and he will exploit any opportunity he sees. So you know, there's some work to be done, but it's still early, and I think both camps will make the necessary adjustments.
Although he raised a valid point, Donik, a valid concern, no? In that, sabi niya, they cannot be parang held, parang hostage by the prosecution dahil kailangan din nilang maghanda. How important is it for the defense to be given sufficient time to prepare for their cross-examination?
Napaka-importante nun, Mark. Kasi kung halimbawang sinimulan sa Article 8 ng prosecution ng kanilang paghain ng impeachment ngayong araw, siyempre, mas maari mong maisip na hindi ganun kahanda siguro ang defense counsel. Pero, mabalik lang ako dun sa tanong mo. Palagay ko si Justice Cuevas, he's also strategizing his approach to the case. Alam niya hindi na kailangan na magsalita pa siya tungkol doon sa ordering ng paghain ng grounds for impeachment, no? Lamang siguro gusto niyang i-impress sa Senate tribunal, sa impeachment body, na unang-una, the prosecution should not be given that much leeway. So they want them to conform and to bear in mind that the defense interests also has to be borne in mind. Ano yung mga interest ng defense? Nangunguna na doon yung kanilang pagiging handa na itaguyod yung kanilang ebidensya laban sa prosecution.
Nick, may press briefing nagaganap sa press briefing room. Punta po tayo doon.
Question, please.
Marlon Ramos, Philippine Daily Inquirer. I-clarify lang namin, hindi nyo kinoconsider na legal victory yung junking ng motion para isubpoena yung mga property?
Sa amin, maganda yon. In a sense, that is an initial victory. Initial, no? Kasi alam nyo, kahit sa isang mahabang laban, meron tayong maliliit na battles. And there is a war. Yung araw na ito ay meron kaming advances na nakuha. Ayaw lang naming sabihin na, hindi, ganito yung nangyari. Hindi po. Maganda po sa amin yon at masayang-masaya po kami. sa naging resolusyon ng Senado. Dahil po, una, sinabi noon, nirecognize nila ang marital privilege. Sabi nila, ang asawa ay hindi dapat tawagin. Pangalawa, nirecognize rin po nila ang filial privilege na ang mga anak hindi mo naman pwedeng tawagin para mag-testify laban sa magulang. Pangatlo po, nirecognize rin po nila na ang na si Chief Justice, bilang siya ang nakasakdal, bilang siya ang respondent, wag mo naman siyang paupuin sa witness stand at tanungin mo siya na makakasama para sa kanya. And that is a right guaranteed to everyone. Kahit sa bawat isa sa atin under the Constitution.
Sir, did it add to your confidence na may mapanalo nyo yung...
Ano po?
Nagdadagdagan yung confidence na
Alam
may
niyo,
papanalo nyo?
yung to be honest with you, we live by the day, we prepare by the day, and we pray a lot.
Ikaklaro ko lang, yung pagboto ngayon, hindi sa amin, hindi namin tinitignan yun na pinapaboran si Chief Justice Corona. Kasi nga, kasi klarong-klaro nga sa konstitusyon, sa rules of court, at sa mga dating desisyon ng korte, na ganun talaga ang batas natin, na nag-e-exist to bago pa man maging Chief Justice Corona, talagang ganun na yung batas natin. Hindi mo mapupwersa na incriminate ng isang akusado ang sarili niya, pati ng kanyang mga, o mag-testify laban sa kanya ang kanyang asawa at pamilya. Ang kinakatuwa namin ay nang nasunod ang batas, na sinunod ito ng senator judges at na ang kanilang desisyon ay sang-ayon sa batas. Yun yung masaya kami.
Magandang hapon po. Lemon Rainier po, DZAS.
Yes.
2 points lang po. Yung tungkol dun sa pahayag ni defense lawyer Serafin Cuevas. Una kasi sabi niya, we are ready to answer, no? Kung ano man yung i-raise ng kabila.
Yeah.
And then, nung sinabi ng kabila na, article number 2 na lang. Tapos kasi yan ang pinaghahandaan namin. Nung na-counter sila sa point na yon, ang sabi ng kabila ay, ng prosecution, hindi sila handa. And then si Attorney Cuevas, sabi niya, pwede pala yung ganun to that effect So, hindi rin kami handa. I think, doon nagkaroon ng second recess. So, ano masasabi niyo doon sa point na yon? At saka, yung sa issue ng lumalabas kasi para bang ito ano lang implication lang or siguro sa interpretation ko lang. Kasi nung unang dapat yung prosecution side ang kumontra do sa major issue sa simula ay tila si Senadora Alan Peter Cayetano ang parang nag-take ng role na yon. Please comment on the 2 points.
Okay, siguro tingnan natin yung mas malaking picture dito, no? Kasi binigay ninyo yung sa sinabi ng prosecution, na sinasabi ng prosecution na gusto namin Article 2. Ang sinasabi naman ng depensa, ang gusto namin ay Article 1. We have to look at it in a proper picture, in a bigger picture, kung bakit nakansela o na-postpone po ang araw na ito. Kasi ang gusto rin ng mga senator, judges, na sila ay, that they are informed, that they are not caught by surprise. Kasi sila po ay kailangan rin mag-aral at sila po ay susuri ng mga testigo. So gusto nila, makita nila yung manner ng presentasyon ng ebidensya. Yun po yun.
Sir, do you interpret that na sa overall preparation ng prosecution
Yes.
side? Meron ba kayong pananaw sa point na yan?
Of course, meron ho kaming pananaw yan, but of course, that's a matter of strategy that we would like to keep to ourselves sa ngayon po.
So, anong gagawin yung paghahanda para bukas naman?
Sisimulan po natin yung Article 1. Inaasahan natin yung Article 1 na sinabi po na order of presentation. Unless na mabago at inform kami, susundin po namin ang nasa impeachment complaint. Si Karen po.
Meron pa ba kayong tatanong?
Any more questions? Si Iskon muna. Si Ms.
Sir Jing Castañeda sa ABS-CBN. So, tomorrow, Article 1 will be tackled?
Hopefully.
So, hindi pa settled yun, di ba?
Kasi ang sinasabi ng mga senator judges kanina, pagkasunduan at ipresenta na ng prosecution.
Correct.
Binigyan nga sila ng pagkakataon
Yes.
na sunod-sunurin. Ano ba yung gusto ninyo? Gusto mo mamauna ang 8? Gusto mo mamauna ang 2? Ganun intindi
Yes,
natin. Hindi pa
rearrange.
gusto mo mamauna ang 1? Or anong pagkakasunod-sunod? Baguhin ba natin? Kung maalala nyo, parang naputol tayo sa aspetong yun, no?
Yes.
So, hindi ako magugulat kung bukas magsasubmit sila ng order.
Okay.
Ng request for order of presentation.
So, whatever new order of or arrangement, di ba?
Yes.
They'll submit tomorrow will be, I don't know, will you accept it?
Yun po, malalaman natin bukas sa floor. Siyempre, kailangan po bigyan kami ng advance notice niyan. Dahil makapag-prepara po kami. Ang bottom line ho kasi dito is preparation.
So if they'll submit it tomorrow and you'll only be informed tomorrow, then you have no chance to prepare.
Parang ganun ho po. Parang ganun po ang mangyari.
So mapopostpone na naman.
Well, depende nga ho yan kung ano isasabit nila bukas.
So unless they
If they submit it today, kung makapag-submit po sila, ayon po ng sinabi kanina, baka po makapag-prepara kami ngayong gabi. Malaman namin kung anong una. At I would want to be very clear, ito pong ginagawang ito, hindi lang po para sa amin, kundi para sa senator judges rin. Dahil nakita nyo naman po, si Senator Angara, sinabi niya, dapat bigyan nyo kami ng advance notice. Kasi yung mga staff namin, i-ready rin mga dokumento para sa amin, para makasunod kami sa kwento na ibibigay ninyo. So, yun po yun.
But as far as you're concerned, you will still prepare for Article 1 tomorrow?
Opo. Lagi naman po.
Rex, Nino, can we give Tina a chance first, tapos si Nino? Hindi ka man nagtao. Si Nino na lang, si Nino. Nino, please use the microphone, please.
Si Congressman Tupas will insist daw tomorrow na Article 2 pa rin. So would you prepare pa rin yung sarili nyo na maghanda for Article 2 or you still prepared to be prepared on Article 1?
You want to answer that? Yung kami, syempre sa ngayon, nakita na namin, may Article 1, may Article 2, pero we will prepare that. But we have to see the real picture kung bakit rin na-postpone ito no? Ang sinabi ng husgado ng Senate President, sabi ng Senate President, ano ba ipipresenta natin? Di ba? Meron ba tayong testigong ipipresenta sa araw na ito? Ano pong kasagutan nila? Wala po kaming testigong ipipresenta ngayon. Meron po kami mga dokumento. And for that reason, sabi ng Senate President, hindi naman po pa atape pwede na walang testigo. Kasi po ang bawat dokumento, bago makaabot sa record ng husgado, ay kailangan pong ina-identify ng isang testigo. So doon po tayo nabite, doon po tayo umabot. Kaya po ang nangyari, kaya tayo na-lead doon sa postponement or yung pagtigil ng proseso ngayong hapon po ito.
Idadagdag ko lang dyan. Kung maaalala nyo sa proceedings, nag-issue na ang Senate President ng subpoena ducis tecum, meaning meron na silang in-order yung Register of Deeds na mag-produce ng mga documents at ito'y para sa prosecution, para matulungan sila na kumuha ng mga ebidensya. Ang problema lang, ngayon gusto nilang unahin ng Article 2, pero yung mga dokumento na kailangan nila na kung saan nag-issue ng subpoena ducis tecum ay wala pa. Kaya sinabi rin ng Senate President bakit ayaw niyong antayin yung subpoena ducis tecum. At ang sinabi naman nila ay dahil meron na sila ng mga computer-generated documents nga. Ang problema lang, hindi tayo nakakasigurado sa authenticity nitong mga document na to. Kaya baka masayang lang yung oras ng senator judges.
Sure. The defense is still saying na you are prepared with all articles na nirereklamo kay Corona. Bakit yata biglang-bigla na, di ba in a trial, nasa prosecution yung unang linyadang magpe-present. Then later on, the defense ang magka-counter nito. So, ito pa lang, parang ngayon pa lang na magsisimula yung prosec na linya at time pa lang nila naihadlang na yata kayong defense.
Hindi ho hadlang yon. Kasi sa bilang abogado, bilang abogado at mga abogadong nakikinig at mga senator judges rin na bihasa sa batas, makikita ninyo na gusto nila, tama yung prosecution, pwede ka magpresenta. Pero ang gusto nila, maayos na pagpipresenta. Ganun rin po ang depensa, maayos na pagpipresenta. Kasi ang kagustuhan natin dito, hindi lang matapos, pero maipresenta in such a manner na naayon sa konstitusyon at naayon sa batas. Para po pag nagdesisyon, ang Senator President ay maliwanag po. Hindi lang po ang Senate President, kundi ang buong Senado, maliwanag po sa kanilang isipan. Yun po ang gustuhan nila, kung ano ba talaga ang mga ebidensyang pinesenta sa kanila.
Cheryl.
Sir, Sherry Ann Torres, GMA7. Hi, ma'am. Sir, yung kaninang admission ng prosecution that all they have is a parang computer-generated documents,
Yes.
Does it somehow weaken or uncovered some more weakness as far as the prosecution team is concerned?
Alam nyo sa... You want to take that?
No,
okay.
sige,
Okay. Yung, alam mo, yan ganyan kasi marami, alam kong tatanungin nyo, weakness. Alam mo sa batas, mayroon tinatawag natin, a lawyer could be candid to the court. Alam mo yun, yung magiging tapat siya. Sinabi niya, itong dokumentong ito, ay ito lang nakuha namin, walang testimonya. Mas magugustuhan pa nga ng husgado kung tapat ka tapat ka na sa kakulangan mo ngayon, hindi nangangahulugan, na bukas hindi mo na ready, hindi ka na ready. Maaaring bukas ready na sila. Hindi po natin masasabi yon. Hindi natin masasabi kasi sa ngayon, naintindihan namin kayo ng press bilang hindi naman po lahat kayo abogado, no? Ang parang, 1 point. Ganyan. Ngayon, 1 point naman sa kanila. Hindi po ganun didesisyonan ng Senado ang ang kasong ito. Ito po yung mababase sa substance and relevancy ng mga ebidensyang ilalapag sa kanila po. Hindi po ganun.
Next questions.
Okay. Wala na po.
Okay,
Okay, isa lang.
meron pa isa, siguro. Maybe we're down to our last 2 questions. Okay?
Sir, the Supreme Court has decided not to issue TRO regarding the impeachment versus the Chief Justice reaction.
Ano yan? Balita? Ngayon lang?
Kanina po, yung SCN Bank decided not to issue.
Okay. Sa tingin ko yan ay yan ang tinatawag nating kortesiya. Ako sa tingin ko, yan ay bilang kortesiya na gusto ipakita ng ating hudikatura na ang proseso ay nandirito. I would want to be very clear. Yan ang information na binigay mo sa akin. Hindi ko pa rin nababasa kung ano talaga anyo sa article at kung anong background ng totoong nangyari. Nagbibigay ako ng opinion, nagbibigay ako ng sagot na ayon dun sa sinabi mo na ang TRO, okay, na hindi maglalabas ang TRO ang Supreme Court dito. At dahil narinig ko yan, sasabihin ko sa inyo, ang tingin ko, my personal opinion is, kurtusiya po yan. Dahil nga nandito na sa Senado, nakikita nila na baka mas mabuti na nga na makita na yung proseso. Ganon po.
Any nadagdag kayo, Attorney Imeno? Okay, we're ready to take the last question, siguro. Unless there are no more questions, okay, we would like to thank Attorney Imeno and Attorney Tagio.
Thank you.
Siguro
Maraming salamat.
bukas ulit sa ulitin.
Yes.
Okay? Thank you very much.
So, sir, spokesperson on the side of the defense, sila po yung nagpaliwanag kung anong nangyari. Nick, nabanggit nila, although hindi pa nga yun katapusan, hindi pa syempre pangalawang araw pa lang, but they're happy with the ruling of the presiding or the ruling of the Senate in this particular instance, ng buong Senate dun sa kanilang motion na hindi na mapapatawag yung asawa, mga anak, at yung manugang.
By a vote of 16-4.
Right.
At syempre, hiningan din siya nung yung reaction niya dito sa Supreme Court decision na hindi na daw mag-issue ng TRO laban dito sa paglilitis sa Senado. Sabi niya, kortesiya daw yon ng Senado dahil nakikita na yung nangyayari dito ngayon. Ay, puntahan muna natin ang ating kasamang si Charina dyan sa labas ng Senado. Charina?
Pansamantala nga munang itinigil ang pagdinig sa loob ng impeachment court at katatapos lamang ng press conference ng defense team at doon nga inilad nila ang kanilang pagkalito kung ano nga ba ang mauuna sa 8 artikulo ng impeachment case laban kay Supreme Court Chief Justice Renato Corona. Pero ayon nga sa isang panayam kay Representative Niel Tupas, mauna munang talakayin ang Article 2 kung saan sinasabi dito ang hindi pagsasapubliko ng Statement of Asset, Liabilities and Net Worth ni Chief Justice Renato Corona. Ito ay pinangungunahan ni Pangasinan 6th District Representative Representative Marlene Agabas. Pero nga dahil dininay nga ito ng impeachment court dahil ito nga daw ay paglabag sa constitutional rights. At ayon din sa defense team, karapatan ng pamilya ni Corona na hindi tumestigo laban sa isa't isa. At yun nga kaugnay din dito yung Article 3 ng 1987 na there's no person shall be compelled to testify against himself. Sa ngayon nakikita nyo sa aking likuran ang media or dito kami ang media na busy sa paghihintay sa mga impeachment watch team na pwede namin makapanayam ukol nga sa nangyayari sa loob ng Senado. Yan muna ang pinakauling balita dito sa labas ng Senado. Balik sa inyo, Mark and Nikki.
Kay Mark, alamin naman natin anong sinasabi nila sa Facebook at Twitter, no? Maraming nagre-react dito sa mga nangyayari dito sa Senado.
Maganda dahil nakikita natin sumusubaybay ang buong bayan. Twitter.
Okay, sa Twitter, sinasabi, I believe weather lang yan. Look at ERAP now laughing at GMA and giving advice to Corona.
Okay, yan po si Muntingting. Sabi ni, yung pangalawa, from Twitter. From Twitter, kay Josh Blue, number 18. Sabi ni Corona, kaya daw siya gusto i-impeach kasi takot si Noynoy na ibigay ang Hacienda Luisita sa mga magsasaka. Yun yung sa press conference niya sa speech niya sa Supreme Court.
Okay, meron pang isa. From Andrew Adrales, don't be afraid if you're fighting for what is right.
Angelica Torres says, naisip ko lang kung paano naatim ni Corona na idamay pa niya ang family niya para sa pagsisinungaling. Sabihing wala talaga siyang kinalaman sa lahat. Yan, kailangan patunayan kung talagang kasama ba talaga.
At sa Facebook, second day na ng trial, manunood ako ulit sa live streaming. Sana diretso pa rin ang coverage katulad kahapon. Yeah, man. Oy, dire-diretso po talaga.
Makakaasa kayo. Sa Facebook, Nikki, ang mangga ay hindi magbubunga ng santol. Ganyan si CJ Corona kasi nagmana siya sa amo niyang si Gloria pagdating sa korupsyon, kaya bagay silang dalawa na mabulok sa kulungan. Oh, medyo mabigat na mga komento yan.
Okay, sa Facebook pa rin, masyado nang lumaki ang ulo ni Corona dahil kay Gloria Arroyo. Sana matapos na yan para sa taong bayan.
Justice long been dead. CJ Corona as long as your Chief Justice. Naku, Nick, I'm hoping though that as we progress at nakita nila yung proseso, that we will talk or they will tweet more about the process and evidence and hindi yung sa emosyon lang or dun sa kanilang personal conclusion, ano. Kasi nakikita natin na sa araw na ito, sa tingin nyo ba, Attorney Caloy, na makakatulong kasi na-observe natin yung ating mga taong bayan, napaka-emotional pa rin yung judgment
Alam mo,
pa rin.
gusto ko lang i-clarify, no? Kapag na-convict siya dito sa impeachment court, he is not going to be jailed, di ba? Hindi naman. Ang penalty lang dyan is matatanggal siya sa pwesto.
Yes.
Oo, kaya kailangan ganapin ang proseso to. However, can they file a case against him sa criminal court?
Posible.
Pwede yun.
It will be a separate matter, pero posible yun.
Pwede yun. Kasi kung merong ebidensya laban sa kanya na enough to convict no, sa criminal, miling mag-iiba na ang quantum of evidence or yung kailangan hanapin na evidence. Tama po?
Yes, but the impeachment court would have ceased to exist by that time. So tapos na ito, you know, it depends what else will happen to him afterwards.
But that can only happen, hindi yan pwedeng simultaneous, that can only happen kapag natapos na itong impeachment trial. Pwede bang simultaneous may magsampa ng kaso laban na sa kanya?
It's possible.
It's possible.
Balikan natin, Nick, yung sa press con, binanggit nila na siyempre gusto nilang maghanda. At correct me if I'm wrong, settled na magsasubmit yung prosecution ng schedule, di ba? At sa papasa na nila yan sa depensa. So, ibig sabihin, hindi na pwedeng magsabi yung depensa hindi sila handa. Tama, Attorney Joey?
Gaya nung sinabi ko kanina, palagay ko si Justice Cuevas naman, gaya ng sabi ni Senate President Enrile, nakahanda na sila ng kanilang mga arguments at kontra-ebidensya doon sa mga grounds of impeachment na hinahay.
Okay. We see Charina, nandyan po sa labas ng Senado, no? Puntahan natin, tingnan natin kung anong nangyayari sa labas. Charina?
Pero dapat yan ay inayos kagad na mabuti ng prosecution panel sapagkat yan ang isang pamamaraan para mapabilis ang proseso. Sapagkat sa isang paglilitis, dapat ang prosecution ang nagbibigay ng paraan para mapadali ang nasabing paglilitis. Mabuti na lamang at binigyan pa sila ng warning ni Senate President Enrile sapagkat maliwanag dito na hindi preparado ang prosecution at kung ang isasabit nilang mga dokumento ay yung document na computer-generated umano, under the rules, hindi maaaring tanggapin yan. Kaya mabutit na pagbigyan pa sila na magkaroon ng postponement. At lumalabas pala ngayon na ang kailangan lamang ang hihingi ng prosecution ay to postpone o ipagpaliban ng nasabing paglilitis, medyo nabigo ang taong bayan na sapagkat ang taong bayan ay umaasa na matatapos ang presentation ng evidence nila at least for one article of impeachment. Well, unang-una, dapat pag-aralan nilang mabuti yung mga ebidensyang ihasasabit nila at pangalawa, pag-aralan nila kung alin ang pinakamalakas nilang mga articles of impeachment na kailang ihaharap sa korte. At kung sa tingin nila, may mga ibang articles doon na hindi naman masyadong malakas, para mapabilis, maaaring lang i-waive yung ibang kasong yun at mag-concentrate na lamang sila sa mga kaso o issues na inaasahan nilang malakas talaga ang kailang ebidensya. Okay? Oh yes, sana naman sa susunod ay maging malinaw kung alin talaga mga susunod nilang mga ilalabas.
Sir, meron ba talagang rules na kailangan walang mauna?
Wala naman, pero dapat ganun ang mangyari sapagkat yun ang order ng presentation nila at siyempre in fairness to the defense panel na naghanda sa number 1, dapat number 1 yun. Kung sinabi lang kami naghanda sa number 2, hindi sila naghanda sa number 1, naghanda sa number 1 ang defense at hindi naghanda sa number 2, hindi matutuloy ang kaso. Kaya kailangan maliwanag kagad yun. Thank you. Salamat.
Okay, that was Attorney Makalintal, ano?
Election law expert. Nabanggit niya, Nick, na importante ang prosecution. Yung prosecution has the obligation na padaliin ang proseso. Pero, Attorney Kaloy, pakipaliwanag, araw-araw itong trial na ito. Hindi kagaya ng regular na court, Nick, na once a month normally ang scheduling ng ating mga korte.
So you have a lot of time to prepare.
You have time to prepare, secure your witnesses. Ito araw-araw. Explain to us kung gaano ka-challenging for the prosecution.
I agree with you. Nakadagdag sa stress and level of difficulty ng prosecution team. We are not used to daily trial in the regular court scene. Sometimes 1 month apart, sometimes more. So I charge this to opening jitters, a bit of inexperience, which they admit. But for them to be effective, they have to find a way to regroup and to let the evidence come out so that they will be judged not on the basis of how they perform in open court, but how good is the evidence? Is it relevant to the issues, to the charges being made? Attorney Tranquil, my good friend, mentioned that it should not be like a basketball game by points, and I agree. It's not by points per day. It's at the end of the day, how good was the evidence? So we're still a long way from that, and both sides have some homework to do.
If you were sa prosecution team, how would you, let's say, gusto mo nga na article number 2 kaagad, no? Hindi ba, call mo yun it's your time Hindi ba dapat ipagpipilitan mo na, ito yung gusto ko kasi kami nga ang magpo-prosecute bakit ayaw nyo kami sundan? Parang gano'n. Wala bang gano'n yun?
Yeah, I agree. If it's, I would have argued that way, that this is my presentation of evidence. I should have more say on this than the defense. Why is the defense telling me how to present my evidence? I think one of the flaws in their, maybe it's remedial though, is that they probably divided it too much according to the articles. And I don't know, I can only speculate, but if you do it that way, there's a tendency for it to be disjointed. So now, today is a reminder for them that they need to coordinate. Even if you're not on the team for Article 2, you have to have some overall view, a macro view of how their team is doing.
And on the defense side naman, paano nga naman sila din makakapag-prepare kung ganun ba yun na pag-presenta, let's say, ng prosecution ngayon, ito yung ebidensya, ito yung mga testigo, agad-agad na ba ang rebuttal o magre-recess muna para mag-prepare sila a few days? Paano? How will this go?
It depends. Attorney Salvador was correct in saying that it depends on what is being presented by the prosecution. So obviously, logic would dictate if it's something voluminous that needs to be studied, you need more time. If it's a list like what they are going to submit tomorrow in the form of a manifestation as to the order, I don't think they need 3 days to study that. But that's only my personal opinion.
Pakikwento din, Attorney Joey, in relation to the question of Nikki, ano ba talaga ang halimbawa, nagpresenta ng ebidensya, ano yung sequencing ng pagpresent sa rule ng prosecution tapos sa rule ng ebidensya, yung basic on a per evidence basis na pagpresent?
Ang mangyayari siguro dito sa ating impeachment trial, magkakaroon, again, uulitin natin yung general principle siguro ng a little bit more flexibility and leniency. Pero siguro with the objective of having an orderly presentation of evidence, ang mangyayari siguro is that someone from the Land Registration Authority or the Register of Deeds, insofar as the Article 2 ground for impeachment is concerned, will be called in to testify to the authenticity of the certificates of title na pinipresenta as documentary evidence of the ownership of Chief Justice Corona and his family of these properties in question. Ngayon, pagkatapos na may...
Yan yung tinatawag na direct examination, attorney, no?
Yes. Ngayon, pagkatapos na may presenta ito, depende kung merong objection ang defense na questionin nila ang relevance or admissibility of this evidence, bibigyan din sila ng pagkakataon na i-express o i-manifest ang kanilang objection. Kung wala naman, hahayaan din naman sila ng presiding officer at ng Senado na i-examine itong mga documents na pinipresent. Okay. At pangalawa, pwede rin nilang batikusin itong officer na tinawag para magtestigo sa authenticity of these titles. Oo, at lalo na itong mga computer-generated documents from the Land Registration Authority. Baka tanungin siya, talaga bang alam mong tunay itong mga dokumentong ito at hindi ito na fake at hindi ba dahil computer-generated ito, hindi naman ikaw ang nag-issue nito. Anong personal na kaalaman mo tungkol sa
Ang
dokumento?
ibig ko nandun talagang palitan. Pag may presenta, ipresent, iko-cross. Pag hindi siya yung ipresenta lahat, pagkatapos ng lahat, tsaka sila isang beses din. On a per evidence basis, magpapalitan.
If something new comes up on cross-examination, the one presenting evidence can redirect. And then, if something new comes up again, recross.
So, hindi
one after another.
hindi matatapos until mag-move on yung prosecution sa susunod. Tama po?
That's correct.
Ang nagtataka lang ako, bakit asan yung salin? Hindi ba isasabi na ito? In question, bakit wala ako naririnig na?
Magandang tanong yan. That's one of the allegations in the articles of impeachment. I believe they stated there that up to now, it's very easy for the Chief Justice to just set aside technicalities and attach it to the articles of
At tama ba
impeachment.
na the subpoena has been issued for the SALN? So it should be expected na sa
Meron
mga
na ba
darating na
subpoena for the
araw,
SALN?
ipaproduce na yun ng yun ata yung nabanggit sa
Parang
press
wala
briefing
pa eh.
kaninang umaga na meron ng pinadala for the SALN to be produced.
Actually, it's very dangerous to, in my opinion, not to release it sooner because baka maging kagaya ng second envelope scenario under the era of administration. There is a clamor, I believe, on the part of the public to know what's there because that's the best way to find out kung if he's telling the truth or not, if the properties are in or out. The danger is if it turns out that the properties are outside of the SAL and it's difficult, almost impossible to put up a defense for that.
At mukhang wala namang indication na yung defense will object to the subpoena for the SALN to be produced, di ba?
I don't recall any objection.
Wala pa doon.
So talagang willing naman sila. At sabi ni Chief Justice Corona, willing naman siyang ipakita yon with the proper venue. So this is the proper venue. Tama, Attorney Joey?
Oo, at wala rin naman tayong maisip na justification ayon sa Republic Act 6713 or ayon doon sa even under the internal rules of the Supreme Court na pwedeng i-cite ni Chief Justice Corona para hindi i-release ang kanyang SALN for public disclosure.
Pero ito ba kagaya ng nangyari, remember the interview of Mikey Arroyo tungkol sa kanyang SALN na hindi nalagay yung kanyang property sa Estados Unidos and all that at sinabi niya na, ay, hindi akong gumawa niya, nagkamali. Pwede bang sabihin ni Chief Justice Corona yung ganon?
Pwede niyang sabihin pero siguro ang epekto ay pareho dun sa epekto kay Mikey Arroyo na pinagtawanan ng taong bayan dahil pumipirma ka doon na sinasabi mong this is true as to my own knowledge. So pinapatunayan mong tama ang nilalagay mo sa SALN.
Pero mukhang malinaw ang issue, no? Dahil ang sinasabi ni Chief Justice, 5 ang property ko. At yun nakapaloob sa aking SALN. At sinasabi ng prosecution, mas marami pa sa 5. So talagang malinaw kung ano yung patutunayan nila. How is it easy or is it hard to prove? Well, please answer that, Attorney Caloy, sa pagkatapos nitong interview na or sa
Kala
report
ko abutin na alas 5 o alas 6. Yung pala, katulad kahapon, after 1 hour, na-postpone na kasi mukhang hindi handa yung mga parties to litigate, no? So, it's disappointing because they should be ready by now and especially there's an indication that as sinasabi before na itong mga congressmen, magagaling na congressmen, but they are not really trial lawyers. So, baka may kahinaan talaga ang kapabilidad nila. Pero let's see, let's not judge them this early. Anyway, they won yesterday a victory when the preliminary hearing was not allowed. Today, it was the time of the turn of the defense to win a victory because the subpoena that the prosecution filed to subpoena the Corona family was not granted, and subsequently the ruling of the Senate President was sustained by a 14-6 vote. Dapat talaga mag-aral pa sila ng gusto at kailangan alam nila lahat yung mga dapat gawin. They should have known that you cannot just present a document without the authenticating officer present to authenticate to its genuineness. Lalo na ngayon, these days of computer, anybody can produce a computer document. You and I can produce the same document. We can go into the websites of LRA and get the same information. So, maliwanag naman na hindi pwedeng tanggapin basta computer-generated document.
So you can say na sir na 1-1 ang score ngayon?
Medyo, pero 1-1 ang score sa dalawang panig, 2-0 for the Senate President. Okay. Sige. Thank you.
Oo.
Alright.
Then yung may ganung kwentuhan, Nikki, na 1-1, ano, gustong mag-count ng gano'n, parang boxing.
Parang basketball
Oo, pero hindi nga, malinaw na hindi nga boxing. Pinaliwanag nga ni Attorney Caloy kanina. That was, by the way, former Senator Maceda, who is also a legal expert, isang top-notcher din ng bar, at talagang matinding trial lawyer din.
Meron lang ako katanungan dito sa mga properties, ano? Kasi meron nga silang sinasabi na yung isa sa mga properties divide into 5 para sa mga anak daw. Pero paano yun? What bearing will it have kapag nakita yung titulo nung isang property na nasa pangalan ng anak, ano yung gagawin? Kasi it's not under his name naman, pero nasa pangalan ng anak. Paano yung connection nun? What is the bearing of that on the case?
Sa tingin ko, if it's in the name of a son or a daughter,
Yeah.
I think the next logical move would be to inquire if the son or daughter has the capacity, financial capacity, to acquire that. And the inference is that if they do not have the financial capacity, it was probably the father, the mother.
Or let's say, sabihin nilang inheritance.
But inheritance has documentation.
To help our kababayans understand, sa ibang countries, sa first world countries, masyado mabilis mag-check ng mga property ng tao. Sa ating bansa, attorneys, mahirap bang mag-trace or meron tayong sufficient safeguard sa ating sistema na para malaman natin kung sino talaga ang totoong may-ari or sino talagang tinatawag na beneficial owner nitong mga property na ito? Meron ba yun sa ating sistema?
Sa ating sistema, konti lang ang title check companies. But it's easy to check with the Register of Deeds directly if you know where the property is situated, who the owner is. It's very easy. You just need to make a request and they will give you a certified copy of the title.
At nakikita doon kung kanino nang galing o kanino nabili.
History, yes. You have to spend time there and go over the other records because hindi lang titulo ang involved. You have to review the transfer document. It could be by donation or sale. But yes, the answer is it's possible.
Okay, meron pang kausap ata si Sari ng iba pang mga
PGL,
leaders sa lobby.
Magpuyat sila ng gusto para may prepare nila yung kaso nila. Hindi naman sapagkat one article is a complete may personality by itself yan eh. Hindi naman parang narration yan na parang born legacy yan na one chapter after the other yan. May kanya-kanyang istorya yan eh. Yung bawat. Okay lang eh. Okay lang yun. Nakuha naman yung prosecution na gusto nila na baguhin ng konti yung proper presentation, yung presentation ng mga ebidensya nila. Well, tama naman kasi na hindi mo pwedeng subpina yung si Chief Justice sapagkat siya accused, ano. May point naman si Alan Cayetano as far as yung pagtistigo ka na asawa mo, kapatid mo, sapagkat ang rule dyan pwede mong i-object yung pagsasalita kung ayaw o kaya ayaw nung akusado, no? Dahil may tinatawag na privileged communication. Kasi ang ibig sabihin yan hindi mo naman alam kung anong tatanungin Baka naman tatanungin, mahal mo ba si Chief Justice Hindi naman pwede, hindi naman incriminating yung sasabihing mahal nila yung tatay nila. Well, anyway siguro, as far as kung ang tingin nyo round 1, round 2 yan parang nakuha ni Pacquiao yung una, nakuha ng kabila yung sumunod na.
Puntahan muna natin, may press briefing ang prosecution team, ano? Ngayon po nangyayari na dyan sa Senado.
To Congressman Kim po. Pero again, since we're recording it and some stations are carrying it live, use the microphone kasi kuminsan may sagot, hindi alam yung question. Okay, we'll start with the first question. The young lady, please.
Sir, Kat Domingo from Global News Network. Echo ko lang po yung major question kanina sa floor. Why did the prosecution come in na hindi masyadong prepared? And comment lang po sa sinabi ni Senator Angara kanina na sayang lang yung oras kanina because your side did not come in prepared.
Well, first of all, I think that's a misconception na hindi kami prepared, no? We were prepared. The prosecutors, the head prosecutors were prepared. In fact, we've taken the liberty of bringing the documents that we were going to present today. There at least there are over 100. There are over 100 documents, land titles, etc. Deeds of sale, deeds of absolute sale, condominium certificates of title. They're all here. There are tax payments here. There's a receipt. We were supposed to present this today and mark them in evidence. And we were supposed to present the person who would authenticate these documents. But unfortunately,
Sir, quick follow-up lang po. You were aware naman po of best evidence rule as stated by the defense panel. Why did you not bring in the witnesses today or why did you not bring in the original copy of those documents?
Well, first of all, as admitted by the Senate spokesperson, Senate Tribunal spokesperson this morning's briefing, the subpoenas were only issued this morning. And because they were issued this morning, I guess that they didn't reach the witnesses that we were supposed to present on time. So what we had were photocopies of documents that these witnesses would have authenticated.
in addition, these are actually originals, so they comply with the best evidence rule.
Siguro linawin ko lang, no, yung these are authenticated copies, just like when you go to the NSO, so you see that, no, yung ito talaga yung dapat ipipresenta. There were supposedly 2 witnesses today. You have to remember we were ready to present the evidence today and mark them. Now, the 2 witnesses that were supposed to be present today because of the subpoena actually was issued only this morning are going to be here tomorrow. In fact, hindi lang ata sila dalawa, but we were ready to present it. Now, the situation was, sinabi, do you have witnesses? We did not need witnesses. We wanted to mark all these almost 100 or more than 100 documents today as evidence. In fact, as you can see, we've already written down the provisional markings, no? Yung Exhibit O-0-03 and the like. So, these are documents that are admissible in court. Now, there was a little bit of confusion earlier when there was a statement that you should have brought originals. We cannot bring the originals. The originals are with the Chief Justice, which he refuses to actually admit today. So our only evidence available, which is admissible in court, are these evidence that we wanted to mark today. But since obviously there was also a confusion as to which article was going to be presented, 1, 2, 3, or 4, I think there was really an overtaking of all the debates that were ongoing. And besides, Congressman PD made a decision on the floor, particularly when Justice Cuevas said that they were not ready to cross-examine on Article 2. He said that. So as soon as he actually said that, Congressman PD made the decision that out of fairness, anyway, the witnesses will be arriving also tomorrow, particularly to authenticate. Then we can defer the proceedings until tomorrow. But certainly, the prosecution has been ready from since Monday, since yesterday, and we were ready today. In fact, like I said, just for the provisional marking of these documents would probably have taken at least an hour because we would have presented the matter and allowed the defense counsel to actually examine these documents. Now, unfortunately, that did not take place, but of course, it's all a lesson learned for all of us. I think what needs to be said here is when we said from the very first day, it's over and done with. We, with utmost respect to the Senate, of course, if we had a pre-trial, it would have been clear for us to delineate all the issues as well as even the order of presentation. But we strongly believe, like with any prosecution for that matter, even Justice Cuevas has admitted that in terms of sequencing, it is always up to the prosecution to make that presentation. If an accused, or even in civil cases, when you make a presentation on cases, whether it's a case for breach of contract, you can actually start with damages, meaning yung dulo ang pwede mong pag-usapan instead yung simula. If a person is accused of multiple crimes, you can start with whichever crime. Now, the sequencing, as far as we are concerned, were never in any way related to strength or flow of discussions. But nonetheless, we will submit and follow the disposition of the Senate Impeachment Court that had suggested that we come up with an order, which is also fine as far as we are concerned.
Sir, hindi ba kayo nag-isip ng option or hindi nyo ba in-anticipate na baka hindi tanggapin yung mga dokumento dahil Xerox lang ito?
Hindi siya...
These are not Xerox.
Hindi siya Xerox, no?
Oo.
Hindi siya photocopy.
These are original, although they are computer generated. Tama si Congressman Barzaga, these are original documents. If you look under, it says Land Registration Authority, unofficial copy if not of blue color. These are accepted official documents. Complying with the best evidence rule. Ang sabi sa best evidence rule, when you're presenting a document, you must present the original, and these are considered originals.
So sir, wala kayong plan B? Dahil hindi nga lumusot yan?
Hindi, there's no need for a plan B. We will just continue the same plan for tomorrow. We will present these documents along with the witness, the custodian of these documents.
Linawin ko lang, no? Like I said, these are all birth pains, di ba? Like we said from the beginning, sabi natin nung simula na talagang kung may birth pains dito, ang disadvantage namin sa prosecution is kami yung magbe-bear ng brunt ng birth pains. Kasi hindi malinaw, hindi kakaiba, ngayon lang nangyari uli ito. So nagkakaroon ng mga pagbabago-bago. So when Congressman PD said that these are machine copies, he did not mean these are photocopies. And I think there was a little bit of confusion there. What we're simply saying is, this is the evidence, and this is the evidence as will be presented, and we are certain will be admissible. What would have happened today, we will again do tomorrow. So, but like I said, nagkaroon na ng maraming debate, so nagkaroon na ng kalituhan, particularly nung sinabi nung defense that they were not ready to cross-examine, in his own volition, sabi ni Congressman PD, let's give them an opportunity so we can defer the matter for tomorrow.
Sir, question. So babaguhin niyo po yung sequence ng articles of impeachment, yung pagiging presentation nito sa impeachment court, yung articles of impeachment. Hindi yung 1 to, as we see it now, na 1 to 8, yung magiging presentation niyo. Pwede niyo na ba sabihin sa amin kung ano yung magiging sequence?
Well, we can tell you that we'll start with Article 2, as already stated this afternoon. No? Now, with what would come after that, that pinag-uusapan ngayon sa prosecution room para maging maliwanag rin sa Senate Tribunal at sa defense.
Okay. Sir, ano yung effect ng ruling ng impeachment court not to allow the Coronas to testify?
We're still assessing on our options as far as that is concerned. But I think certainly we would have wanted more debate on that matter. If parties would have been allowed, in fact, Congressman P.D. Barzaga had a very lengthy memorandum on this matter. If he were probably allowed to speak and ventilate on the issues pertaining to the validity of the subpoena, I am certain that he would have been able to convince quite a few number of senators. But be that as it may, the presiding officer, the Senate President, had already made a ruling. So as far as we are concerned, we are just thinking of our options on what to do there. But what is significant is, what strikes us is the irony, no? Na si Chief Justice Corona has spoken about all these titles line by line before the public in front of the Supreme Court. And that, in effect, is practically a waiver on his part as far as self-incrimination is concerned. But they continue to use all these technicalities, in effect, to cloud or to reject any means to get into these titles. Parang whenever it's convenient, they use these technicalities to be able to stop us from actually determining their SALN. What is the second development after today? Isn't it a coincidence that in one respect, they raise a major objection on self-incrimination on all these properties when in fact he has already been talking about it in the public? Secondly, the Supreme Court issues a decision en banc that now throws the matter pertaining to the disclosure of the SALN subject to the consultation of the other justices, including the members of the Court of Tax Appeals. So, obviously, like as we said, is that there seems to be roadblocks being put up for us to be able to get through that SALNs of the members of the Supreme Court, in particular the Chief Justice.
Okay, so binago niya ba yung strategy na nilatag ng prosecution yung ruling na yun ng impeachment court? Nabago ba? Mababago ba yung inyong
Hindi naman. Kailangan natin balikan, no? Isa sa mga rason rin kung bakit ni-request namin yung subpoena laban kay Chief Justice Corona para makatulong siya para ilabas yung katotohanan. Ngayon, dahil hindi ito pinayagan, dahil sabi nga ni Senate President Enrile, self-incrimination yan, hindi ito ibig sabihin na hindi namin makukuha yung mga dokumentong yan sa ibang paraan. No? Masabi po natin, pangarap po na sana namin na mas magiging kasangkapan sana si Chief Justice Corona para madali yung paglabas ng katotohanan. Pero dahil nga ang tingin ng Senate Tribunal, ito ay self-incrimination. O sige, we submit and yet we can produce the documents that we are asking for.
Alam niyo po yung right against self-incrimination, nag-originate yan sa 12th century sa Europa nung may tinotorture silang mga prisoners para hindi mag-incriminate ng sarili. Kasi minsan tinotorture na, sinasabi nila yung kahit hindi nila ginawa, sinasabi nila ginawa ko yan. Kasi tinotorture na sila. So that's the origin of the right of against self-incrimination. Ano? So kung isipin natin, that is invoked by an ordinary citizen against the full might of the state. He's telling the state with his arms folded, sige, i-prove nyo yung kaso nyo against me. I won't speak against it. That's what the citizen is saying. Sa amin, Chief Justice Corona is not, hindi naman siya ordinaryong tao. Siya ay Chief Justice, hawak niya ang buong hudikatura. Meron siyang 12 dekampanilyang abogado. Why does he have to invoke this right which is intended for ordinary citizens? Diba? Sabi nga niya, sasagutin niya punto por punto. Sabi niya sa speech niya, handang-handa siya sagutin punto por punto yung mga akusasyon dito sa impeachment. Tapos sasabihin niya, bakit pa siya nag-hire ng 12 lawyer? Tapos sasabihin niya, tatahimik pala ako.
At sana yung pakiusap namin, the ruling that we would have been hoping is tulad ng kung paano ang Senado i-conduct ang kanilang mga hearing, is to allow the person, tulad ng sinabi ni Senator Cayetano, is to allow the person to be present and let the person invoke for each question na propounded. Kapag tinatanong na siya, na tingin niya may katungkulan o maaaring ma-incriminate siya o maaaring ituro niya ang kanyang pamilya, maaaring tamaan siya, ay doon niya i-invoke yun. Pero yung blanket na hindi natin papayagan mag-appear, parang siguro gusto sana naming ma-reconsider yun. Even no less than President Bill Clinton in his own impeachment testified, and that's the President of the United States during his impeachment. So, ganun sana ang inaasahan namin. But like I said, we are deliberating on what to do as far as that ruling is concerned. We will always submit to the mighty will of the Senate.
Sorry, sir. Sir, I'll just follow up first on the one of Congressman Angara. Kasi you were saying na parang si Chief Justice, parang mighty person, so he should be able to answer all the questions and then just do it on a question per question basis. But does that mean then that it follows na let's say you as a congressman or let's say the senator judges as senators are also powerful people in a sense, then that they too should appear before courts and just, waive the right against self-incrimination?
Question is, should we also waive our rights if we were appearing? No, I think the point is, Pia, he's already been speaking in public about these things. Why not speak in the proper forum? Diba?
But then, kasi parang he might say nga na parang, if I'm compelled to do this, then maybe other government officials should also be compelled to do the same thing.
Yeah, I think what Sunny meant was, we're not asking him to give up his right against self-incrimination. What we're simply saying is that it be used in the context of the impeachment proceedings. these are not accusatory or criminal proceedings. I think it's important that a witness can always show up, just like here in the Senate. You cannot refuse not showing up on the basis of your right against self-incrimination. You have to show up, pero i-invoke mo yung right kapag tinatanong na sa'yo. Yun ang dapat sanang nangyari kung masusunod kami. But it's not asking him entirely to waive, no? Kasi for him to not entirely show up, I think is, well, we don't entirely agree with that decision, but if that's going to be the final decision of the Senate, then wala kaming magagawa. But we will find every way to find evidence against him. If he's not willing to show up and say the things that he's been saying all over the city, then we will find other ways to establish it.
Sir, sorry, just one last follow-up. Kasi parang the way it works rin kasi always in hearings is na so what you're saying is once he's there, that's the only time he should just say parang if only he doesn't like the question, then that's the only time he should waive his right against self-incrimination?
That's how it works. That's how it works, except in criminal cases. If the accused is, there's fear of incarceration, which is not present today.
Which is why Congressman Tupas also made a reservation regarding the pronouncements with due respect of our presiding officer that this is akin to a criminal case. Kasi pag binasa nyo naman yung mga legal authorities, very few will say that it is akin to a criminal case. Kasi ang penalty lang niya removal from office and perpetual disqualification from holding any other positions in government. So there are more authorities who say that it is akin to an administrative case in fact.
And sir, last. You mentioned, sir, earlier that Congressman Barsaga parang made a decision on the floor. Does that mean na parang there was no plan talaga to have this postponed and you really just wanted to push through with it? And is it something that the other members of the panel would have wanted talaga na to have it postponed already?
The prosecutor on the floor is the captain of that day. I mean, let us stress that. Kung sino nakatayo doon, siya ang gagawa ng desisyon at susuportahan namin ang kanyang desisyon. At ginawa niya yung desisyon na yon base sa pagtingin niya nung sinabi na nga ni Justice Cuevas na hindi sila handa. Sabi niya, out of indifference, let's give them an opportunity. Why don't we postpone it for tomorrow? But when he wanted to mark the documents, there was already a confusion as to are you going to have it marked or are you going to present it in evidence with accompanying testimonial evidence? Mukhang dun na ho, hindi nagkaintindihan ng mabuti. So, in deference, he said that we're probably better off just postponing everything. But like we said, we are ready with all the documentary evidence for presentation today. Even if there was no witness, we could have done our marking. And in fact, as we will show tomorrow, we will still go through with what we should have done today.
Sir, regarding ito dun sa summons on the Corona family, ang sabi nyo, you would have wanted a lengthier debate on it. Pero si Congressman Tupas naman ang, kumbaga, seemingly agad-agad na bumigay o nag-concede dun sa argumento. Ano pong comment nyo dun? Tsaka dun sa reaction afterwards na some are saying it might have showed your inexperience in an arena like this.
It's different when you're on the floor, no? When the Senate President had already spoken, and in fact, as he was about to manifest the reservation na sabi niya ay kung pwede, bigyan kami ng pagkakataon makapag-file ng aming motion for reconsideration. Obviously, the Senate President had already made a decision. And I think, he wanted to defer like any of us when a ruling is already made on that matter. And in fact, obviously, when the Senate President has already said that, although we did not see what happened in the caucus, obviously the Senate President, para pag sinabi na ng Senate President yon na pwede ho ba mag-file kami ng motion for reconsideration, in the middle of it, the Senate President already says that, sige, pwede, pero tandaan mo, ito ng, obviously, alam na ng Senate President then that it has already been decisively decided upon by the caucus. And si Congressman Tupas saw it already. Nasabi niya, I think that this matter has already, and the votes later on would have shown na decided na sila on that matter. So, bakit pa natin pipigain kung alam naman natin malinaw na nagsalita ni Senate President at yung kanyang pananalita ay malinaw na suportado ng karamihan or ng malaking mayorya. So, hindi yun inexperience. In fact, I think it was clever of him to have done that instead of antagonizing the Senate President. But we really would have wanted a longer debate on that matter.
Okay, I think it's deadline time. That was the last question, unless meron pang isa. Okay, I think that's the last question. So, thank you very much again, members.
very much,
Members of the prosecution panel, itong communications team nila. Oh,
si
Congressman
Well,
Farina.
ako nga, kararating ko galing sa bakasyon, kaya wala akong alam talaga. Oh, of course. Oo. Oo. Thank you.
Is he
Alright,
part of the...
kakagaling lang daw niya sa bakasyon. He's part of the prosecution team also,
He's the
ano?
congressman from Ilocos, and he's also a bar top-notcher, Congressman Farina. So, I don't think there is a lack for legal minds there. Medyo siguro mayroong, yung kalawang talaga is showing a little bit.
Kasi matagal, sa mga to, matagal nang hindi nakapag-practice. Most of the naging mga congressista, representatives sila matagal. Kaya, but anyway, balikan natin si Charina. Meron siyang bagong interviewin. Charina?
Natapos ang pagdinig sa pagbigay ng warning ni Senate President Juan Ponce Enrile sa prosecution kaugnay nga sa hindi nagtugmang artikulong pinaghandaan ng magkabilang kapwa at yun nga yung prosecution team at defense team. Pinaghandaan nitong prosecution yung Article 2 kung saan may kaugnayan sa SALN ng Supreme Court Chief Justice Renato Corona, habang ang defense team naman ay naghanda na sa Article 1 na may kaugnayan sa mga kaso kinaharap ngayon ng Arroyo administration. Kaya na nga nakapanayam namin si Attorney Romulo Macalintal, Attorney Erwin o Attorney Ernesto Maceda at si Dean Amado Valdez, at mukhang hindi nga daw ito araw ng prosecution, pero nangako naman ng prosecution na magiging handa na sila bukas at sa susunod pang araw ng paglilitis. At yan po lahat ng mga detalye nangyari dito sa Senado Live. Ako po si Zarina Lusuegro.
Maraming salamat, Charina. At kanina nga nagkaroon ng press briefing itong prosecution team, and they were saying they have pinakita pa nila over 100 documents, mga deeds of sale, mga titles, na handa silang ipresenta na original ito, no? Official documents ito. But hindi na ipresenta kanina, no? And the Senate President was asking itong si Representative Barsaga kung if he wanted it marked, ano? Ano ba yung proseso sa ganyan when you present itong mga dokumento for evidence?
Well, marking would have at least there will be a purpose to the coming together today. Since the documents are there, just number it, and then mark the portions of the different documents that have a bearing to the allegations in the complaint. So it's just a way of filling the time. I think that was the opening that was being given by
Was
by
that
Senate
what
President.
Representative Barsaga wanted to do, or because he was given a choice by
I'm not sure if he answered. Did he answer? I don't think he responded.
So mukhang malinaw talagang the work is cut out for them. Kailangan ng remedyohan. But this is not the end for the prosecution team. And is there major damage to the case of prosecution? That's my last question for you, Attorney Joey.
Sa aking pananaw, hindi naman na-damage ang objective ng ating prosecution panel na maihain ang charges at ang evidence laban kay Chief Justice Corona. Sabihin na lang natin siguro na nagkaroon ng konting gusot sa kanilang effort na maipresenta itong mga evidence showing the ill-gotten wealth of Chief Justice Corona. Pero if you take the big picture approach, hindi naman talaga masyadong apektuhan ang kanilang objective of proving their case.
Kumbaga, masasabi natin technical lang or procedural yung mga napag-usapan sa araw na ito, hindi pa talaga dun sa meat ng ating pinag-uusapan. Tama, Attorney Caloy?
Yes, like what Congressman Kimbo said, this is a roadblock, and as most trial lawyers know, the objective of putting a roadblock is to ruin the tempo of the other side. And as you saw today,
Pag ganito ba nakaka-demoralize? Hindi naman.
Well, it depends. If it happens all the time, nakaka-demoralize talaga. So at least the prosecution can concentrate now and not take for granted procedural aspect. It's not only the hard evidence that matters in arriving at the truth. They have to do it in a way that is clear to the senator judges, a way that they can understand it. So if there will be too many distractions, they might have a hard time.
Maraming salamat, Attorney Caloy, Attorney Joy. Maraming salamat sa inyong expertise sa araw na ito, and we're hoping that you both will be back in the coming days.
Thank you very much.
Tuloy-tuloy pa rin yung ating coverage, live coverage ito Paglilitis, and we hope to have you here again in the coming days.
Naging makasaysayan ang araw na ito. Maraming kaganapan, marami pong napag-usapan at napanood po nating lahat ang nangyari sa araw na ito. At hindi naman ito unexpected dahil, Nikki, yung siyempre mga abogado ni Chief Justice Corona handang i-debatehin ang bawat issue na ipipresenta. Ito yung recap, panoorin natin.
Nakikita natin ang pagsasagawa ng hearing si Senator Joker Arroyo, no?
Prayer. Si Senator Joker Arroyo were to start the session for today. Senate President banged the gavel, tapos ayan na po ang majority floor leader para sabihin yung order of business or kung ano po yung magaganap sa araw na ito. Ayan na po si Congressman Tupas para ipaliwanag yung mga posisyon nila sa mga motion na didinggin o didesisyonan.
At ang unang nangyari, yung may mga motions sila na didesisyonan. No? Isa na dyan yung whether to allow itong pagsabpina sa pamilya ni Chief Justice Corona para tumestigo. And the Senate, after deliberating, no, nag-recess, they voted 16-4 na yung hindi na sila payagan o in agreement with the decision of the presiding officer na wag nang payagan na tumestigo itong pamilya ni Chief Justice
What
Corona.
was interesting in the manner by which or the process kung paano nila inaffirm yung decision ng presiding officer ay yung pagtayo ni Senator Alan Peter Cayetano to question or to raise an objection dun nga sa ruling at unang-una sinabi lang niya reservation lang but eventually it moved towards actually a motion to amend the resolution or of the presiding officer which led to the presiding officer dividing the Senate at taking a vote para sa isyung yun.
Yung klaruhin lang natin, no, yung question kasi ni Senator Alan Peter Cayetano is whether to ipatawag itong son-in-law ni Corona para mag-testify, no? Kasi hindi naman siya immediate family member.
So yung son-in-law, yung mga anak at yung asawa at nag-agree si Senator Alan Peter na siyempre yung right against self-incrimination applies to the Chief Justice pero feeling niya dapat hindi muna pre-empt na mapatawag yung asawa at mga anak at yung son-in-law and just allow them to make an objection as the questions, incriminating questions are asked. Pero hindi nga po yun ang naging ruling ng Supreme Court at maganda naman ang sinabi ni kahit na 14-6 ang
correct lang natin, no? 14-6 yung votes, no?
At, pero mukhang the prosecution team from the press con nabanggit ni Congressman Erin Tañada na they're taking this in stride. Hindi naman ibig sabihin wala silang ibang paraan para patunayan yung mga allegations nila even if the Senate parang dininay na nga yung kanilang request na ipatawag yung Chief Justice at yung kanyang pamilya.
Ninais lang sana ni Senator Cayetano kasi nga ayaw daw niya maging president ito na sa mga susunod na mga dapat ipatawag nakakaroon itong technicality di ba? But maliban doon, meron na rin medyo debate din sila dito sa pag-present ni Representative Barzaga as to kasi gusto Article 2 ang unahin at nag-object naman ang defense doon.
Ang naging usapin ay sino ba ang magdidesisyon kung anong uunahin doon sa 8 articles. At sabi, siyempre gusto ng prosecution sila magdidesisyon. Nag-object ang depensa dito at ang ruling naman ng presiding officer ay hayaan ang prosecution na i-arrange nga kung alin doon sa 8 ang kanilang uunahin at ano ang susunod pero kailangan nilang i-inform ang depensa at ang pati yung mismong Senado para makapaghanda naman itong mga senator judges para sa gaganaping mga pagdinig nga na trial para malaman nila dahil kailangan ng preparation lalo na kanina nakita natin they had to decide on a legal issue siguro if they were able to foresee na posibleng mangyari yon nakapaghanda silang ng mas maganda.
Sinabi naman ng prosecution team sa kanilang press conference na handa naman sila. As a matter of fact, hawak nila yung over 100 documents yun lang siguro medyo nagkagulo as to whether ano ba papamark ba yon o kaya ipepresenta na yung witnesses nila along with the documents.
That's right. Oo, makikita natin Congressman Tupas, at nakita nga natin si Congressman Warzaga kanina, mukhang nakikita natin na kailangan talaga ng konting ayuda or konting tulong ng prosecution team coming from litigation lawyers, yung medyo nagpa-practice pa talaga ng kanilang pagka-abogado ngayon dahil medyo merong mga technical aspects ng pagpresenta ng ebidensya, pagpresenta ng witness na baka nga kung matagal ka nang hindi nagpa-practice ay marahil ay nakalimutan mo na.
Ito nga ang defense team naman dahil praktisado, talagang katakot-takot naman yung mga objections.
So kung posibleng sabi nga ni Attorney Caloy kanina, this might be a good time for them to raise the issue back to the presiding officer na hayaan silang magdala or magbitbit ng kanilang mga private prosecutor para tumulong sa kanila.
At ito nga sinabi ni Angara na sana maging orderly, pati sinabi ni Joker Arroyo, maging orderly itong presentation, bigay sa kanila yung arrangement para yung mga senador din makapaghanda.
Right. Ang interest po ng both sides, I'm sure, is an orderly process na mabilis. I'm sure ang interest ng Senado, ng presiding officer, ay mapabilis din ito at lumabas ng maayos at malinaw yung ebidensya. Siyempre, tayong lahat, pati na tayo dito, Nikki, at lahat ng ating nanonood na kababayan, yan din po ang ating gusto.
So, bukas, aantabayanan natin yung pagpresenta nila ng ebidensya at mga tetestigo dito sa Article 2. They've already decided, Article 2 ang uunahin.
That's right. Okay, so aantabay pa rin po tayo. Hindi po tayo iiwan dito hindi tayo aalis until this is completed. Kaya you can keep on following us through our websites, sa aming FB and Twitter page. And yun po, nag-express po kayo ng inyong mga opinion at mga komento kanina. I would encourage you to weigh the evidence and give your comments as well on how this whole process is unfolding. Hindi lamang dun sa ating emosyon para mas lumalim yung ating balitaktakan.
Okay, so bukas po antabayanan nyo. We're live sa PTV, IBC 13 at Radyo ng Bayan. Meron din pang live streaming ang Paglilitis, pati na sa Facebook and Twitter.
Okay, ayan po, ito po ang Paglilitis, Katarungan para sa Bayan. Magbabalik po kami bukas. Ako po si Attorney Marcos Rodes.
At ako naman si Veronica Baloy Jimenez. Magandang hapon po sa inyong lahat.